continue to the next date.
Last may fix a date, my lords. That's
No,
all. Only my request.
We don't know. Yes.
14th, maybe. Lordship may have it on 14th, my lords.
Move it, sir. Yes, sir.
My lord, ಇದು settle ಆಗಿದೆ ಕೆಳಗಡೆ ಕೋರ್ಟಲ್ಲಿ.
Settle ಆಗಿದೆಯಾ? After vacation ಹಾಕ್ಲಾ?
No, my lord. This is third time receive ಆಗಿದೆ notice ಕೂಡ.
ಏನ್ ಮಾಡೋದು? Settle ಆಗಿದೆ, settle ಆಗಿದೆ.
Wash ಮಾಡ್ಬೇಕು ಸ್ವಾಮಿ.
Enter ಮಾಡಿಲ್ವಾ?
ಇಲ್ಲ ಸ್ವಾಮಿ. Washing ಎಷ್ಟು ಕೇಳಿದ್ದಾರೆ ಅದರಲ್ಲಿ.
This court on 29/20/24 had passed the following order. In the light of the respondent complainant is yet to be represented. Serve ಆಗಿದೆಯಾ?
Serve ಆಗಿದೆ ಸ್ವಾಮಿ.
Is served on so and so. And has is served on so and so. 20?
28.
So the parties to the list have entered into a settlement before the family court in MC 6068 of 2022, which recognizes the cooperation for closure of the present proceedings. The paragraphs which depict such closure reads as follows, page 29. The respondent complainant, though served, remains unrepresented even today. In the light of the said order, said settlement arrived at between the parties in MC so and so, the proceedings against the petitioner husband are required to be obliterated, disposed, quashed. Next.
Much obliged.
Respondent number 2.
10 lakhs.
Hotel.
ಕೊಟ್ಟಿದ್ದಾರಾ?
No, my lords, they have not paid.
We have made arrangements for
Huh?
the petitioner's wife. She's pledged all her gold and she's made arrangements of 5 lakh rupees. I will, if it's passed over, I will make the payment right now. 5 lakh rupees. Because
ಈಗ ಎಷ್ಟು ಬರಬೇಕು?
Its total is still about 70 lakh.
70 lakh rupees, they keep bloating figures out of nowhere. I don't
This
understand.
was the
What is
figure
this?
last time, it was not opposed.
35 lakh rupees.
Then we'll
is the
dismiss it straight away. ಅಷ್ಟೇ.
total.
Kindly,
He's
madam.
on a single limb.
Maybe
He is in
dismiss.
custody only in this case.
No
Only.
problem. We'll dismiss it, fine.
Well,
Let the law take its
No, my
course.
lords, the issue is this, no.
Issue ಏನಾರು ಇರ್ಲಿ, I will
My
not
lords,
interfere at all.
there is persistent prosecution on him. What has happened, my lords, in the recent past before the learned magistrate? Learned public prosecutor asks
ಈಗ
me,
what is your ground, sir? Tell me, sir.
my lords, I'll make the payment.
What have you challenged, sir?
The registration of the crime, filing of the charge sheet, entirely on the ground that, my lords, this is civil in dispute. Further, my lords, they approached the learned, consumer forum of Mysore, seeking, my lords, return of the money that they have paid.
Correct. How much money they had paid?
35 lakh.
35 lakhs.
Please.
ಈಗ ಇಂಟ್ರೆಸ್ಟ್ ಸೇರಿ ಎಷ್ಟಾಗುತ್ತೆ?
It's
35 lakhs
approximately
ಯಾವತ್ತು ಕೊಟ್ಟಿದ್ದು, sir?
2012, my lords.
2012.
Please, please.
All right. ಈಗ 10 years, for 12 years interest. You have enjoyed the money. Unjust enrichment.
But if I'm
ಅಟ್ಟು ಕೊಡ್ಲಿಲ್ಲ, ದುಡ್ಡು ಕೊಡ್ಲಿಲ್ಲ.
if I'm outside, my lords, I will be able to make
No,
payments.
First you make payment inside, then we will see after you come outside.
But for me to make payments, I must come out.
No,
That's
no.
the issue. my lords.
I will not do all that.
But I'm
You are in custody now.
I'm still in custody. It's been over 1.5 months.
I'll
since I'm in
dismiss it. You
custody.
will be there only.
Kindly, my lords, I have no other recourse, my lord, but
No, sir.
Only 3 pages may I point out, my lords.
but I'm willing to
42,
give him money.
Page
Or, my lords,
42.
I'm under instructions. There is a new project coming up. I will give him a property free of all encumbrances.
Just 3 weeks.
My lord,
No,
that
my
the,
lord.
the valuation of the property is 96
I'll-
lakhs.
I'll-
20 lakhs, 26
Bedwa.
lakhs beyond, my lords.
No, my lords.
ಬೇಕಾ?
Yes, my lords. The reason is this, please take page 42. Sale,
Sometimes discretion is the best part of valor. Just see.
I'll, lords, I've inquired with the clients also. Their instructions are that there is no trust left on this developer, my lords. They've
No,
cheated
if
him.
he is
outright.
giving a property free of all encumbrances, which is 96 lakhs,
Please.
take it.
My lords, he's saying cash itself he's not able to pay. While in custody, I don't see how he's going to transfer title to immovable property. my lord.
My lords, I will come
Please
up.
see only
My
3
lords, may
pages.
kindly see. My lord, the issue is public prosecutor, there is vested prosecution on me. On a date, my lords,
ಇಲ್ಲ ಬಿಡಿ. ಈಗ ದುಡ್ಡು ತಗೊಂಡಿದ್ದೀರಾ, ವಾಪಸ್ ಕೊಡಿ.
ಕೊಡ್ತೀವಿ, my lord.
ಇಲ್ಲ ಅಂದ್ರೆ
It is our
ಅದೇನ್
corporate duty.
ಅಪಾರ್ಟ್ಮೆಂಟ್ ಕೊಡ್ತಾರೆ ಅಂದ್ರೆ ಕೊಡಿ.
We will return it now.
It
I have
difficult-
no other choice but to
Return
return.
ಅಂದ್ರೆ I will dismiss this.
Return the
You
money
can't
or,
take, you can't take your own time.
no, my lords, I will return the money or make, register an
Or ಇಲ್ಲ.
property.
ಈಗ if they are wanting apartment, let them tell.
In their
No,
discretion.
my lords,
Please.
my instruction.
bow down to
Can
my
I
lord.
just point out, my lords, what is page 42, my
So I
lords?
will dismiss it. Not a problem at all. I will straight away dismiss.
Kindly, my lord.
No, I will.
Even there, my
Lords,
lord,
I am at my
Mysore,
lords.
in Mysore, learned trial court observes, with great difficulty, the man is taken into custody. He absconds. and there is collusion between the police and the accused in the sense
that
that
is why, my
they
lords,
they
they bring
file
me
a
on a
false.
date that it
I'll
is- I'm not
complete.
supposed to be listed.
I'll
Please.
complete. The false proclamation affidavit. Man resides in the same address. Still, police files a proclamation over there that he's not residing. With the very same address, he files this petition before my lords. He undertakes to pay before learned previous judge does not.
We're in custody.
I'm still.
And before my lords also, it was undertaken 3 weeks time. My lords were kind enough to provide him. Not a whisper is made to us saying we are in difficulty, give us time. Ivattu, before my lords, they are saying.
Pay 5 lakhs today, my lords.
Anything else?
If my
I'm
lords pass
dismissing
over, my
it
lords,
right away.
my lords, if my lords pass it over, I will pay 5 lakhs immediately. My lords,
That is
today.
up to him to accept it or not. Apartment to accept it or not. This I'm going to dismiss.
Lords, there's only one dispute, my lords, for 35 lakh rupees, my lords. This is an entire civil issue. They have lodged the complaint 7 years after the alleged incident.
Give money, sir.
We will give it, my lords.
Somebody's
but
hard
since
earned
I'm-
money, sir.
Please, I'm in custody, my lords. Otherwise, I would
They
have
should,
made
run,
arrangements.
they should
to-
run from pillar to post for the money that they have given to you in 35 lakh, in 2012, 35 lakhs, which is easily 1 crore today.
After my lords executing a sale agreement with me, he does a sale deed in favor of someone else.
Yes, ma'am.
And then
Wait for not 6, 420.
later, my lords,
Straight.
later just to complete the crime, he executes a rectification deed in favor of someone else saying, I am confirming title in favor of you. ಇನ್ನೊಬ್ಬರ ಫೇವರ್ ಅಲ್ಲಿ ಒಂದ್ಸಲಿ ಅಲ್ಲ 2 ಸಲಿ ಮಾಡಿದಾರೆ ಸೇಲ್ ಡೀಡು ರೆಕ್ಟಿಫಿಕೇಶನ್ ಡೀಡು ಮಾಡಿದ್ದಾರೆ.
It is,
Sorry.
my lords may kindly, my lords may
Petitioner.
kindly pass it over, my lords. I will take instructions and come, please, my lords.
This they've done in
Because
the
the-
past
I'll
also.
take it at 2:30,
Please, please.
only to dismiss it.
My lords, no,
Yes.
the wife is here, my
What
lords. She's pledged
instructions
all
you
the
want?
properties. She has pledged all her jewelry and she's making payments
Nothing,
today.
I don't know, sir.
Please, my lords, my lords, if my lords permit, I will make payments immediately for 5
Whatever,
lakhs.
that is up to him. Yes. Pass over
Please.
to be taken at 2:30. Yes, next.
Number 5.
For the petitioner. Petitioner is the second accused. Offense under the
Objections
pro-
ಹಾಕಿದ್ರಾ?
I'll
ಹಾಕಿದ್ದೀರಾ?
file my list.
ಇಲ್ಲ, ಈಗ ಕೊಡ್ತಾ ಇದ್ದಾರೆ.
You're filing, filed.
I am filing it now.
Ah. Yes, sir. Parcel ತಾನೇ ಇದು.
Parcel. Parcel is addressed, was placed by accused number 1, my lord. He is admitted in 67.
Ah.
And thereafter it is delivered to accused number 3. In turn, accused number 3 would say that at the instance of accused number 2, it has been delivered. Accused number would say that it's accused number 1. Accused number will say, yes, this belongs to me.
Accused number 1.
Yes, ma'am. See, very clear says belongs to me. I have placed the order.
Then why are you implicated?
15A, madam, because I introduced accused number 3 to accused number 1, my lord.
ಏನ್ ಕಾನ್ಸ್ಪಿರಸಿ ಹೇಳಿದಾರಾ?
Conspiracy act.
Hmm.
And then 50A, my lord, is glaring omission, my lord. There is absolutely no ಇಲ್ಲ. ಅದ್ರ ಮೇಲೆನೆ ಬೇಲ್ ಕೊಟ್ಟಿತ್ತು.
ಕೊಡಿ.
Very detailed.
May I, my lords?
Sir,
ಅಷ್ಟೇನಾ?
No, no.
ಹೇಳಿ ಹೇಳಿ.
I'll
Yes, yes, ಹೇಳಿ.
charge sheet. They have not.
ನಿಮ್ಮ ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಕೊಡಿ. ಚಾರ್ಜ್ ಶೀಟ್ ಕೊಡಿ. Yes. ಇದ್ಯಾರ್ದಿದ್ದು?
but in this bail application of the very same case, ma'am.
Ah.
In the very same case, your lordship may kindly
ಇದು
see.
ಯಾರು ಅಕ್ಯೂಸ್ ನಂಬರ್?
I am accused number 2.
ಯು ಆರ್ ಆಲ್ಸೋ.
All the 3 accused were there, 1, 2, 3. So the, this honorable court after assessing the materials. produced-
ಕಂಪ್ಲೀಟ್ಲಿ ಕವರ್ಡ್ ಮೇಡಮ್.
My
ತೂಫಾನ್ ಸಿಂಗ್,
lords,
ಬಲ್ವಿಂದರ್ ಸಿಂಗ್.
50A is, my lords, the word is may, my lords. It's a,
Seriously,
yes, my
I
lords.
have held it to be mandatory,
Mandatory.
My lords, 50A.
violation of which will get the entire proceedings vitiated.
My lords.
There is no choice left for you. Supreme Court also says mandatory.
My lord- my lords.
Maybe statute irbodu. Supreme Court has interpreted to be mandatory. You show me one judgment which Supreme Court says 50 is directory and not mandatory.
I'm not talking about 50.
even
my lords.
otherwise,
It
my
is
lord.
50A, my
Ah,
lords.
50A,
controlled-
sorry, 50A, no
controlled
problem.
delivery, my lords.
50A ne.
50.
50A.
My lord's judgment is on 50 and 52, my lords.
No problem.
I'm referring to 50A, my lords.
Hmm.
My lords,
It is,
I'm
my lord,
sorry to interfere.
controlled-
I'm sorry to interfere. So if the 50A finding is concerned, my lord, bail was granted on the very same reason that it was not complied. That matter, I mean, that is reached finality.
Lords,
They did
that
not
was-
even
All
challenge it.
right. Let her finish it.
Very
Why
well.
are you coming? Yes,
Very well.
lords, in all, there are 5 accused, my lords.
all right.
This petitioner before this honorable court now is, my lords, petitioner number, accused number 2, my lords.
Hmm.
Accused number 2, my lords, books the substance, my lords, in the name of accused number 3. Payment is made by accused number 2, that is this petitioner,
Hmm.
through his cryptocurrency wallet, my lords.
Hmm.
My lords, this was booked into accused number 3's name.
Hmm.
And in the voluntary statement of accused number 1, accused number 3, to whom the dummy parcel was delivered, my lords,
Hmm.
he says it belongs to my friend, Mr. Abhay Kumar, and he is now in hostel. My lords, with the investigation team, accused number 3 goes to the hostel wherein this petitioner stays, and accused number 3 hands over this dummy parcel to the accused number 2, that is this petitioner. He accepts that parcel, my lords. The seized contraband, my lords, substance here is, my lords, 0.560 of 560 grams of LSD. 0.1 gram is commercial
That
quantity.
is, yes.
Yes, my lords. And my lords, accused number 3 discloses his name, my lords. When this petitioner was apprehended, my lords, by the investigating team, he says, my lords, it was booked at the instance of accused number 1. My lords, accused number 1 makes payments to the account of this petitioner. This petitioner in turn makes that payment to the supplier, my lords, through his cryptocurrency crypto wallet, my lords. That those records are available. And, my lords, there are charts between the petitioner and other accused, which will establish, my lords, they were continuously following up the parcel that was booked and to be delivered, my lords. May I take, my lords, and accused number 4 is the supplier, my lords. Subsequent to apprehension of all these 1, 2, 3 on their disclosures, my lords,
Accused number 4 is also granted bail?
he is shown to be in JC, my lords.
It's fine. So he is not granted.
He is
bail.
not granted. Accused number 1 is not granted bail. Accused number 2 and 3 are granted bail, my lords.
Right.
However, at the time of bail, my lords, there was no bank statements that were available with us. There were no clear charts that were available with us, my lord. And, my lords, it was just the voluntary statement that were available with us. And based on that, my lords, to corroborate those voluntary statements, it was held by the coordinate bench of this honorable court that there should have been a controlled delivery process undertaken by the NC. Lords, may I kindly take, my lords, to 50A.
NDPS.
Lords, before that, 28B, my lords.
1 minute.
Definition of control delivery. Two 7B, my lords.
Yes, madam.
Control delivery. What is control? Because that is the ground that is being urged, legal ground.
Yes.
Controlled delivery means the technique of allowing illicit or suspect consignment of narcotic drugs,
Yes.
psychotropic substance,
Yes.
controlled substance, or substances substituted for them to pass out of or through or into the territory of India with the knowledge and under the supervision of the officer empowered in this behalf or duly authorized under section 50A with a view to identifying the persons involved in the commission of an offense under this act.
Ah,
My lords, it is a technique that is being adopted, my lords, with a view to identifying the persons involved in the commission of an offense under this act.
Hmm.
My lords, now 50A.
Control delivery.
Control delivery. A Director General of Narcotic Control Bureau constituted under subsection 3 of section 4 or any other officer authorized by him in this behalf may, notwithstanding anything contained in this act, undertake control delivery of any consignment to any destination in India, a foreign country, in consultation with the competent authority of such foreign country to which such consignment is destined, in such manner as may be prescribed. My lords, this says it may, my lords, by him in this behalf may, notwithstanding anything contained in this act. It is a investigating mechanism that is being adopted by the investigating team, my lords, if it is required. And it is not a mandatory provision that is contemplated under the act which has to be undertaken.
What is the procedure?
My lords, parcel, my lords.
No. Control delivery reliance placement cannot be considered as an exercise of control gets vitiated, non-compliance. Mandatory requirement, what is the mandatory requirement in 50A?
My lords, if at all it is undertaken, there has to be permission from, it has to be by the Director General of Narcotic Control Bureau constituted under
Section
subsection
3
3.
and 4. There are-
This is the requirement, my lords. If it is
Control
conducted,
delivery, any consignment, all right.
my humble submission, my lords, it is not mandatory and hence it is not conducted in this case, my lords. However, dummy parcel was sent to the address, sent with the postman to the address of accused number 3, which was there on the parcel, my lords.
Hmm.
The same was delivered to him. It is received by accused number 3. It is accused number 3 who says, my lords, it belongs to accused number 2, the petitioner herein. Then they go there, my lords.
Hmm.
Now, my lords, the corroborative evidence other than the voluntary statement, my lords, may I indicate that?
Now, which is that?
Yes.
In the charge sheet?
In the charge sheet, my lords.
No, page.
Charge sheet conclusion may kindly be seen, my lords, first.
Page.
The page with this, 26, page 26, my lords, in page 26.
Num petition. Num petition.
Charge sheet, sir, you put in that.
Conclusion.
Now, this is the conclusion that is of the investigation, my lords. This is my lords, first page, it contains how the conspiracy was done, my lords. During the course of the investigation done according to the law, on scrutiny of documents and material objects seized, and based on the voluntary statements of the persons concerned, it has come to the light from the documents seized that Ayush Kishore Bose and Swapnil Joshi have studied in BTS so-and-so. Ayush Kishore Bose was 1 year senior to Swapnil Joshi. The arrested accused conspired the procured drugs by employing network wherein ordering person was different from the paying person. From the bank statements, it is clear that Ayush Kishore Bose had ordered drugs with help of Swapnil Joshi, that's accused number 5, and for payment, Ayush Kishore Bose transferred an amount of 10,100 on 12/6/2023 to the account of Abhay Kumar, that is petitioner, and as requested by Ayush Kishore Bose, accused number 1, Aditya Bhatt had transferred an amount of rupees 6,000 on 12/6/2023 to the account of Abhay Kumar. Further, Abhay Kumar has invested 15,000 from his pocket,
All right.
has invested 15,000, after which Abhay Kumar has transferred 2.82417 XMR on 13/6/2023
Hmm.
from his crypto wallet to the wallet ID given by Ayush Kishore Bose to the value of Indian rupees 31,100 for procuring the seized drugs.
You have the copy of the charge sheet?
I-
Mahesh? Charge sheet copy ಇದೆಯಾ?
ಕೊಟ್ಟಿಲ್ಲ.
ಅದು ನೋಡ್ಕೊಂಡ್ಬಿಟ್ಟು ಹೇಳಿ.
ಕೊಟ್ಟಿರ್ಲಿಲ್ಲ.
No, you look into it and tell me.
Very well.
List the matter on 21st for further hearing at 4 PM.
Obliged.
Interim order ಇದೆಯಾ?
ಇದೆ.
Interim order subsisting shall continue to the next date of hearing. And 50A mandatory gets some
ಇದೆ.
material
I got
if there
that.
is.
I got
Yes.
it. In fact, they have to get over that finding. In this case, only the bail matter.
That's all
Very
right.
clear findings.
Yes, that's all right.
And it's become finalized.
That's bail ultimate. Charge sheet ಆಗಿರ್ಲಿಲ್ಲ.
Finding very same.
Charge sheet ಆಗಿತ್ತು ಅವಾಗ.
Charge sheet was
But the
not-
very same material with the very same ferocity it was submitted.
All right. Velocity may not change. ಇದು ಮೇಡಮ್ ಇದು ನಿಮಗೆ ಬೇಕಾ ಇದು? ಇಲ್ಲ
We
ಫೈಲ್
will
ಇರಲಿ.
take it after the case, my lords. That is the
fine.
investigating.
ಇದು ಇಟ್ಬಿಡಿ. ಫೈಲ್ ಇರಲಿ.
Bill number 6.
For the respondent, your lordship, we will file objection in the next date of hearing.
Just after 4 weeks. IVO. Next.
Lordship, it is an offense of 494, 498, 17.
Yes, sir.
But I have been exonerated of the departmental inquiry. I am accused number 2 and 3. I'm giving.
That's okay.
Lordship, I'll argue this case on 3 grounds, my lordship.
We'll hear it after vacation. List the matter on 21st October.
Not the interim order.
Interim order subsisting shall continue to the next date of hearing. Next.
For the petitioner, victim, advocate victim, 395 and 364A.
Their problem,
It's also
Compromise is not possible.
compromise.
very difficult to compromise.
PW1 has supported the case, my lordship. He has also identified.
Complainant,
Complainant himself.
complainant is an advocate.
Advocate,
Om Kumar appeared and
that is true.
said, "Yenaru madi." I am not pursuing
They
it.
are in custody 3 years, 7 months, my lord. And so far as, my lord, in all 5 petitioner,
Yes, Jagdish.
A5 is concerned, there are no cases. And A4.
ಅಲ್ಲ
nobody-
ಬೇರೆ ಕೇಸಸ್ ಅಲ್ಲಿ ಕಸ್ಟಡಿಲಿ ಇದ್ದೀರಾ ಇದ್ರ ಮೇಲೆನಾ
ಇದೊಂದು ಇದರಲ್ಲೇ ಸರ್.
ನೀವು ಬೈ ಮಿಸ್ಟೇಕ್ ಅಡ್ವೊಕೇಟ್ ನ ಅಟ್ಯಾಕ್ ಮಾಡ್ಬಿಟ್ಟು
ಹೌದು sir.
ಅದೇ problem.
ಇಲ್ಲ ಕ್ಷಮಿಸಿ, it is the my friend only instructed these parents of these petitioners to file this, or else they would not have filed. Subsequently, this is the
ಹೌದು. Himself has said,
himself.
ಆಗಿದೆ enough of custody.
Becomes the rule 364A, my lord, has a death penalty.
The death penalty, whether you can settle it or not, ಹೇಳ್ದೆ judgment ಕೊಡಿ ಅಂತ 364 years.
ಅಲ್ಲಿ ತಮ್ಮದೇ ಇದೆ ಸರ್, ತಮ್ಮದೇ ಕೊಟ್ಟಿದ್ದೀನಿ ನಾನು. ತಮ್ಮದೇ
ಅದ್ರಲ್ಲಿ ಫ್ಯಾಮಿಲಿ ಮೆಂಬರ್ಸ್ ಇರ್ಬೇಕೇನೋ.
ಇಲ್ಲ ಸರ್, ಫ್ಯಾಮಿಲಿ ಮೆಂಬರ್ಸ್ ಇಲ್ಲ, ಅದ್ರಲ್ಲೂ ಕೂಡ ಇದಕ್ಕೆ ಕರ್ಕೊಂಡು ಹೋಗ್ತಾರೆ.
ಅದೇ ಪವನ್ ಕುಮಾರ್ ರೆಡ್ಡಿ.
ಹೌದು. ತಾವೇ
I have followed some other order in that. ಇದು ನೋಡಿದೆ ನೋಡಿ.
I have given, I am enough to give that.
We'll see. We'll take it as disposed. Monday copy.
Please,
Monday or Tuesday. ಏನಾರು ಇದ್ರೆ ಪೋಸ್ಟ್ ಮಾಡಿಸ್ತೀನಿ ಮತ್ತೆ. ಎಸ್.
like Tuesday ತಾವು ಸಿಟ್ಟಿಂಗ್ ಇಲ್ಲ, ಮಂಡೇನೇ.
ಅಲ್ಲ ಮಂಡೇ ಕಾಪಿ. ಕಾಪಿ ಕೊಡಕ್ಕೆ ಅಂತ.
Sorry.
ಎಸ್. ಇಲ್ಲಿ ಬಂದೇ ಕೊಡ್ಬೇಕಾ? ಇಲ್ವಲ್ಲ? ಎಸ್. ಲೆಟ್ಸ್ ಸಿ.
Let's say appear for the respondent. It may be,
ಕೆಪಾಸಿಟಿ.
please, I could not.
ಯಾಕೆ ನಿಮಗೆ ಕೆಪಾಸಿಟಿ?
ಅಲ್ಲಲ್ಲ,
ಬರ್ತಾ ಇಲ್ಲ.
the-
78 ಲಕ್ಷ ಕ್ಯಾಶ್ ಅಲ್ಲಿ ಕೊಟ್ಟಿದ್ದೀರಾ?
ಇಲ್ಲ, the respondent was down with dengue, please, my lords. I was-
ದಟ್ಸ್ ಆಲ್ ರೈಟ್. ಬಟ್ ನೀವು ಚೆಕ್ ಯಾರಿಗೆ ಕೊಟ್ಟಿದ್ದು ಅಂತ ಹೇಳಿದ್ರಿ?
ಒಂದು ದಯಾನಂದ್,
ಇನ್ ದ ನೇಮ್ ಆಫ್ ದಯಾನಂದ್
ದಯಾನಂದ್.
ಅವ್ರ ಬ್ಲಾಂಕ್.
ಫೈನಾನ್ಸ್.
Blank, it is according to
Blank
them, it is
check.
blank.
ದಯಾನಂದ್ಗೂ ನಿಮ್ಗೂ ಏನ್ ಸಂಬಂಧ?
ಫ್ರೆಂಡ್ಸ್, ಫೈನಾನ್ಸಿಯಲ್.
ಎಲ್ಲಿದ್ ಬೇರೆ ನಿಮ್ ನೋಟಿಸ್ ರಿಪ್ಲೈ ಕೊಟ್ಟಿಲ್ಲ ಅವರು?
ಕೊಟ್ಟಿರಿ.
ನೋಟಿಸ್ ಅಲ್ಲಿ ಹೇಳಿದಿರಾ ಅದನ್ನ ರಿಪ್ಲೈ ಅಲ್ಲಿ?
ಹೇಳಿದೀವಿ,
We have denied it.
ಎಲ್ಲಿದೆ? ದಯಾನಂದ್ ಅಂತ ಹೇಳಿದಾರಾ?
ಹೇಳಿದೀವಿ.
No, we have denied it.
ಯು ಹ್ಯಾವ್ ಡಿನೈಡ್, ದಟ್ಸ್ ಅ ಡಿಫರೆಂಟ್ ಥಿಂಗ್. ದಯಾನಂದ್ ಅಂತ ಹೇಳಿದಾರಾ?
ಪೇಜ್ ನಂಬರ್
ಅವ್ರು ಹೇಳಿದ್ದಾರೆ.
29.
29, 5.
ಹಾ ಹೇಳಿದಲ್ಲ, ಪ್ಯಾರಾಗ್ರಾಫ್ 5.
ಅವ್ರು ಹೇಳಿದ್ದಾರೆ, we have denied it, please, my lords.
You may deny, I'm asking. So in the teeth of his denial, you show me this 85 lakh
I
capacity.
will, please, my lord. It may be had immediately after vacation.
All right, list on,
9th ಇದೆ.
ಇರ್ಲಿ ಬಿಡಿ, ಇರ್ಲಿ ಬಿಡಿ.
ಅಲ್ಲ,
My lord,
stay-
I
stay
undertake.
ಕೊಡಿ, ಆಮೇಲೆ ಬೇಕಾದ್ರೆ
ಇಲ್ಲ, I undertake on 9th, we will not precipitate.
ಎಂಟರ್
I will,
The learned counsel for the respondent undertakes that he would seek an adjournment on 9th and not precipitate the matter, i.e. the matter on, the date on which the matter is listed before the concerned court. List the matter on 21st in the fresh matters list.
obliged.
Yes. ಅದಾದ್ಮೇಲೆ ಡೇಟ್ ಕೊಡ್ತಾರೆ ಬಿಡಿ.
ಮಚ್.
ಅಲ್ಲ, it is.
ಅವತ್ತು
it may-
ಕೊಡ್ಲಿಲ್ಲ ಅಂದ್ರೆ I will allow the petition.
Please,
ಎಂಟರ್ ರೆಕಾರ್ಡ್, there is no avocation, there is.
my lords, this is a
All right,
matter
ಬಿಡಿ.
of- But
8 lakhs
I will,
ಕ್ಯಾಶ್ ಕೊಡ್ಲಿ
I will show it, please.
ಪ್ಲೀಸ್. ನಿಮ್ ಬ್ಯಾಂಕ್ ಅಲ್ಲಿ ಇತ್ತು ಕೊಟ್ರಿ.
I am an agriculturalist, it's an agricultural income, I will show it.
Yes.
ಮಚ್.
Remembered Act, my lord, section 104 is not followed. Official witness are only examined, my lord.
ಸೊ 30B ಬಿಟ್ರಿ ಈಗ.
30B, my lord.
ಹಾ ಸರಿ.
My
Next,
other also, my lord, there are official witness, no independent witness, my lord. And there is no information.
no
how they got-
problem. Let the trial go on.
Kindly, my lord,
Yes.
kindly,
ಕೊಡಿ ಕೊಡಿ.
Section 104. Kindly see, my lord, para
ಏನು?
8 and 9. No independent witnesses. The village accountant, revenue officer.
You also don't get judgment, sir. ಅದು 30B ಬಿಟ್ರೆ ಅವ್ರೀಗ. They have taken a different route now.
ಅಲ್ಲ, ಇದರಲ್ಲಿ
Whether this is mandatory, just check.
no, it's
9 and 10 ಇದು ನೋಡಿದ್ದೀರಾ ಜಡ್ಜ್ಮೆಂಟ್? ಹೇಮಂತ್ ಚಂದ್ರನ್ ಗೌಡ ಅವ್ರಿಗೆ ಕೊಡಿ. ಮುಂಚೆ ಕೊಡಕ್ಕೆ ಏನ್ ನಿಮ್ಗೆ ಪ್ರಾಬ್ಲಮ್?
8 and 9. And even witness list, my lord, ಬರ್ಲಿ, official witness. No recovery, no seizure from.
Various mothers, my lord, that they've recorded saying that the people have not supported.
They
So
have not
section
stated-
100 CRPC is
says
talking
they have
about,
not
it is not
stated.
mandatory.
They have not
That's
stated.
what I want.
It's not mandatory. I'll place,
ನೀವು ಹೇಳದಲ್ಲ
sir,
ಬೇಕನ್ನ
I'll place 100 judgments, my lord, which says that section 100 is not mandatory.
ಎನಿಥಿಂಗ್ ಎಲ್ಸ್ ಸರ್
They have not stated in Maharashtra,
Parallel.
official witness, my lord. No recovery.
ಎನಿಥಿಂಗ್ ಎಲ್ಸ್
ನಮ್ದೇನು ರಿಕವರಿ ಇಲ್ಲ. Only ಅಂದ್ರೆ how they got information of.
ಏನ್ allegation ಏನು?
ಅಲ್ಲಿ ಸಿಂಶಾ ನದಿನಲ್ಲಿ ಮರಳು ತೆಗಿತಾ ಇದ್ರು ಹೋದಾಗೆಲ್ಲ ಓಡೋಗ್ಬಿಟ್ರು.
ಸ್ಯಾಂಡ್
Sand.
ಎಸ್
Photographs ಎಲ್ಲ ಇದೆಲ್ಲ.
ನಮ್ದಿಲ್ಲ ಏನಿಲ್ಲ.
ಬೇರೆ ಏನಾದ್ರು ನಿಮ್ದು 100 ಏನಾ ಮಧ್ಯಾಹ್ನ ಕೊಡಿ
I have to clarify that section 30 where coordinate benches have also held.
that time definitely going to do.
Yes, my lord.
ಎಲ್ಲಿ ಆ ಜಡ್ಮೆಂಟ್ಸ್ ಎಲ್ಲ ಮೇಡಮ್ ಲಾಸ್ಟ್ ಟೈಮ್ ಜಡ್ಮೆಂಟ್ಸ್ ಕೊಟ್ಟಿದ್ದಲ್ಲಿ ಕೊಡಿ ಹಾ ಎನಿಥಿಂಗ್ ಎಲ್ಸ್ 100
Yes, I'll give judgment.
After vacation ಮಾಡಿದ್ವಿ.
no
ಅಲ್ಲ,
sorry
ಹಾ.
nothing doing no after vacation don't try to escape the bench yes
No, my lord.
ನಾನೇ ಕಂಟಿನ್ಯೂ
ಅಲ್ಲ,
ಆಗ್ತೇನೆ
ಪಾರ್ಟ್ ಮಾಡ್ತಾರೆ ಇವತ್ತು ಆಗಲ್ಲ sir.
ಪರವಾಗಿಲ್ಲ ಸರ್ ಡಿಸ್ಮಿಸ್ಡ್ ಐ ವಿಲ್ ಕನ್ಸಿಡರ್ ದಟ್ ಎಸ್ 100 ತಾನೇ ನಿಮ್ದು ಇಬ್ರದ್ದು ಆಯ್ತು ವಿಲ್ ಕನ್ಸಿಡರ್
I'll place
ಎಸ್
it.
ಜಡ್ಮೆಂಟ್ಸ್ ಕೊಡಿ ಜಗದೀಶ್
And on that ground, the Punjab and Haryana High Court has set aside the order of conviction also.
ವಿಚ್ ಗ್ರೌಂಡ್ 30B
Under violation of.
ಅದು ಕೊಡಿ ಅದೆಲ್ಲ ಕೊಡಿ there is anything I'll post it back on Monday give it unless Jagdish gives me yes ಅದು ಕೊಟ್ಬಿಡಿ ಜಗದೀಶ್ಗೆ ಇದು ಜಡ್ಮೆಂಟ್ ಕೊಡಿ
Number 11.
Here for respondent two, my lord.
This is a matter which had come up last week. My learned friend was in.
Heard me online and my lord was kind.
oh yes
We had a
354.
heated
Sri Lanka.
discussion online and I apologize for.
Oh,
So my, now it's so much more pleasant, my lord,
Yes.
since my learned friend is here.
yes
My lord,
Ah.
on the last occasion, the court had pointed out the entire sequence of events, put it down in a sequence so we understand it better, my lords. Now, my lords, before I point out the sequence of events that has taken place, my lords, with my lords kindly, my lords, one illustration and an analogy, my lords. I will commence with that, my lords. Now, for any reason, my lords, at the time of my submission, I go to the stage of being a nuisance or annoyance to this court at any point of time.
ಹೌದಾ
At any point of time.
okay
So my lords would tolerate me to the maximum capacity possible. And at one point of time, when I refused to even give up the mic, all that the court would do is summon the marshals, please have him out of the court. Choicest of words may be used, my lords. Probably, if the familiarity that I come off, my lords may be kind enough to use good words in saying, please put him out of the court. But in case, my lords, I turn to be an utter nuisance, please throw him outside the court hall. Now, my lords, if I am outside the court hall, I still continue my nuisance in disrupting the proceedings. Whether I threaten to damage a property or for that reason, my lords, I threaten to commit harm to myself, the court would merely say, marshals, take care of the situation till he is out of the high court. My lords, this is an
why you
illustration.
didn't get a better illustration
My lords, I would use this now as an analogy.
Ah.
Now, my lords, in the same instance,
Hmm.
it happens to be a lady who's arguing.
Hmm.
And the same scenario happens. Now, my lords, would it be possible for them to go to a police station and say, we want a complaint registered under 354, outraging the modesty? Now, compare this, my lords. Here it's an administration of justice, my lords. Please compare this to a company, my lords, where they have to run their affairs. Now, this is the backdrop of the illustration and analogy, my lords, and I will show the sequence of what transpired in the office on that particular day before the complaint is given
No,
6 days
You're
thereafter.
all right. Initially, I told you, yes, it is a misuse prima facie. But I saw mail
So
communication
that, my lords, that
saying that
sequence,
she was not let outside. She was made to stay in the office all night.
I'll show the why it's contrary. That's why the sequence is very important. That's the reason, my lords, I started with this analogy and illustration. I'll point out, my lords. Now,
So analogy and illustration, if we paraphrase to this, you mean to say she was a nuisance inside?
I will.
So
point
you
out.
had to deal with that nuisance.
Absolutely, we requested her to go out. We
Why-
asked her to
No,
leave
you
the
just now
premises.
said no request.
Request, no,
Go
no,
out,
no, no,
then
no.
take care, all that.
I will point it out through the set of mails itself, my lords.
Hmm.
This was not a case of her being detained. This was a case of her being asked to go because the working hours were over. She refuses, stays the whole night.
Her case is that she was detained.
I will show that.
Your case is that she was retained.
No, my lords, I will
Yes.
show from the mails itself. Her own case is that she voluntarily wanted to stay in the office premises. I will point that out. That's where, my lords, slightly the mails, the one that was read was a jumped out mail, my lords. I will show
Charge
you.
sheet ಆಗಿದೆಯಾ?
Investigation
Let
stage.
the investigation
my
go
lords,
on.
investigation stage ಅಲ್ಲಿ 354. The first two accused are in US. The main president and so and so in US. The other are top brass in the company. Please, my lords, for that reason, my lords, the mail should be very necessary. Otherwise, my lords, complaints like this will virtually disrupt any company from carrying out their functions. My lords, on yesterday, in fact, we sent a mail across on some mails and the fact that
Who, the company to the,
we sent it to them, my lords, which we are going to be relying on.
Hmm.
My lords, can you just pass
You're
it
ready,
on?
madam?
Yes, I'm ready. Yes, I've received.
Well, I think last time the understanding was that we will go on with the matter fully, my lords. That was the understanding, I think, even my learned friend.
There appears to be some misunderstanding. We'll take it after vacation.
ಇಲ್ಲ, my lords, this, there's no interim order, my lords. I will have to point out. Otherwise, my lords, companies can't function. Now, please
Yeah.
notice, my lords.
What is building plan?
My lords wanted to know where were the CCTV footage. Why the CCTV footage was not there. My lords, just prior to that.
CCTV
please-
ilva at the place
Hey,
where?
5 places, not on the cubicles. My lords is on the plan, my lords. Please notice the plan.
ಇಷ್ಟೆಲ್ಲ ನೋಡ್ಬೇಕು 482 ಅಂದ್ರೆ
ಅಲ್ಲ,
ಸಾಧ್ಯನಾ?
ತಾವೇ ಕೇಳಿದ್ದು ಯಾಕೆ CCTV
ಅಯ್ಯೋ
ಇರ್ಲಿಲ್ಲ
ಸಾರಿ
ಅಂತ?
ನಾನೇ ಕೇಳಿ ತಪ್ಪಾಯ್ತು.
My lords asked, why did you not record, have CCTV footage?
Hmm.
Now CCTV are placed in 5 places, my lords. If for a minute, my lords, that plan is seen
I've
at
seen,
the entry
yes.
gate. My lords, now this is very important because at night, police has come. At our request, police has come to ask her to go. She refuses to go. She stays till 6 a.m. in the morning, my lords. That all is in the sequence itself. Now, please notice, my lords, 5 CCTV cameras. My lords has that layout, my lords, for a minute. 20 LE, document number 6. ಒಂದು ಲೇಔಟ್ ತಾವು ನೋಡಿದ್ರೆ, my lords.
ಅಲ್ಲ ಅದ್ ನೋಡಿದ್ದೀನಿ.
ಅಲ್ಲ, ಒಂದೇ ಒಂದು ನಿಮಿಷ. I'll explain where the cubicle is, where she was sitting, where this incident happened. My lords, entry gate, ಅಲ್ಲಿ ಒಂದು CCTV camera ಇದೆ, my lords. On that floor, we have 5 CCTV cameras at entry and exit points. The cubicles are on the right-hand side. My lords may notice just after the entry gate on the right-hand side are the cubicles. 1115 is where she was. 1115, my lords. My lords has that.
That's all right to tell me.
My lords, now kindly notice, my lords, the reason why they don't keep CCTV cameras everywhere, my lords has document at page 21.
Yes.
Please notice, my lords, why CCTV is not put. It's only to respect privacy of each of the
I know.
employees.
I saw that.
Yes, my lords.
You
Now,
don't
my
worry.
lords,
I'll be seeing, but I'm all ears.
My lords, she is subsequent to her termination,
Hmm.
issues a notice demanding 1.5 crores, my lords.
Hmm.
That my lords should have as document number 5. I'm sorry, document
Document number?
4. Is it 4?
Four.
I'm sorry, 3. Document number 3.
In fact, that is produced
Document
by
number
us as
3 at page 11.
Oh, this legal notice.
Legal, no, page 11, bottom only, my lords.
Hmm.
11, para 23. Number 2, compensation of 1.50 crores.
Hmm.
And the only other documents which were produced here is, my lords, the annual reports which are given under section 21 of the POSH Act. That is given to the committee every year. It has to be given because they say we don't have a POSH committee, which is factually incorrect. And reports are being given to the POSH committee. In fact, one of the accused shown here, as I pointed out last time, is a member of the POSH committee.
Hmm.
Now, my lords, the sequence of events, please notice, my lords, we have prepared the entire synopsis, exact sequence of event that has taken place there with the mails.
Please give us.
My lords may notice the sequence of events. Serial number 1, that's only the report to the POSH under the POSH Act. Serial number 2 is when she joins the company, my lords. 5/2/2024, second respondent joined the company. Then 9/2, she was asked to do certain online training tasks. She failed to complete it. 23, my lords, discussion between second respondent and so regarding the progress in her role and area of improvement. This happened in March. Now, April may be noticed at page 3, serial number 5, 2/4/2024. Mr. Matthew, my lords, they're in Austin, my lords, in USA. Mr. Matthew recommended putting second respondent on performance improvement plan after assessing her performance till that date. Then, my lords, here we still requested, my lords, you hold on, don't put her into the program. We'll see the improvement. Then the next relevant one, my lords, is at page 4, serial number 7, 4/4/2024. Again from America, my lords, they would say, put her into their program, let her improve in the performance program. Then, my lords, these mails continue, and then she's put into the program. My lords should get that at page 6, serial number 10, 11, and 12. My lords gets serial number 10, 11, 12. She accepts the PIP program. This was on 12/4/2024. The next date is important, my lords, 13. 15th, 16th, and 17th April, quarterly meeting of program improvement plan to discuss the improvement that can be made to the company's products, which were held virtually and had more than 250 participants, including employees and business leaders from all over the world. The program was to discuss the improvement of the company product and not the forum to discuss any employees' grievance. Now, 17/4, the Zoom meeting is going on, my lord. 17/4, during the virtual meeting, second respondent started doing baseless allegations on various processes of the company and started raising her personal concerns that she has been put on PIP. Her colleagues asked her not to bring up certain issues as it is not the appropriate forum. Despite repeated requests from meeting organizers, managers, and other participants to have such discussions separately with her manager, second respondent continued to interrupt the program. To maintain the decorum of the meeting, second respondent was removed from the meeting. Now, this is the starting point of the whole grievance. She is removed from the meeting. However, she continued to send chat messages and emails to all the 250 plus participants in the meeting, raising baseless and irrelevant issues. The senior management from United States of America also did not approve of the second respondent's conduct. 9:32 p.m. Again, my lords, 250 plus larger group of people that she has a right to discuss on so and so idea to solve a problem. That's what it means, my lords. Then 10:32 sent by second respondent to 250 plus larger group of people defaming the company and petitioner for and towards removal of from such a meeting. My lords may notice in the fourth column, we have put it even the page number of the emails. Now, my lords, 10:39, my lords, page 10, 10:39, sent from the management of USA towards respondent number 2's conversation in the meeting in front of the 250 plus larger group of people, defaming the company and discussing about her PIP plan in the meeting, and same was becoming serious and reputation of the company coming down in front of 250 plus participants. My lords, this ends and then comes the date of incident 18/4/2024. My lords, second respondent continued to send emails to all the 250 participants making allegations. My lords, annexure H to H4 in the petition. My lords, then her access to the official email was restricted after that. Then, my lords, 101.26 a.m. night, my lords, she again continues sending these messages, which my lords should get at page 11. And then, my lords, one mail comes from US at 3:40 p.m. My lords gets it at page 12. Please notice this one email, my lords. Mail from Mr. David, president of the company, to stop copying everyone on the mail chain. So, my lords, mail from one more Marcos, senior director at Austin, 4:53 p.m. They again tell her, don't send these mails in the larger group. Now, my lords, serial number 16 is the actual incident. Third petitioner, my lords, Shivani Gupta, My lords, she is the member of the POSH committee here, my lords. She again approached the second respondent along with women's security guard at 5 p.m. for a meeting. Incident has taken place between 5 p.m. and 5:20 p.m., my lords. So the first thing that happens is approach with the lady security to the respondent number 2. The second respondent again started shouting in front of all the colleagues and conducted herself unprofessionally. The third petitioner requested the second respondent to surrender the company laptop, which she refused. On seeing this aggressive behavior, the second respondent, the women's security guard, in the presence of the second and third petitioner, asked her to hand over the laptop and took the laptop from second respondent, which she did not resist. My lords, that may be very relevant, my lords, because her mails also indicate that. Please notice her email immediately after that. I've extracted it in the sequence itself, my lords. Page 14. My lords, page 14 in the sequentially, I've extracted the mail. Our mail, it comes in line, my lords. After this habit of taking laptop, my lords, 18th April, 5:20.
You have highlighted it also.
Yes, my lords.
Yes.
She writes to Austin, my lords. Hi, David. Now the HR
David.
team, Shivani Gupta forcefully took my laptop and she's forcing me to leave the floor. Please note that words, my lords. We are asking her to leave the premises. Then thank you, she says. Then, my lords, at 5:23 p.m., hello, Shivani Gupta forcing me to come for a discussion without scheduling a meeting. I'm keeping on requesting HR to schedule a meeting, but they are forcing me to come to the meeting room without scheduling a meeting. This is what she says, my lords. Then 5:37, hi, David. Shivani Gupta also took my personal belongings, including cash wallet, which was inside my laptop bag. My lords may notice this aspect.
Yes.
Then next mail, she says it's returned back. 6:21 p.m. Hi, my lords. Hi, David. Few minutes back, HR Shivani Gupta sent my bag with physical guard, security guard, but I did not accept it. My lords may notice, my lords, I did not accept it. I suggested security guard to take it back, as I would like to take this matter to external forum and for legal assistance, since no one has right to touch my personal belongings. Then, my lords, 6:53 p.m. Hi, David. I'm not understanding why security is following and controlling me even when I go to the washroom for urination. This is what my lords saw.
Yes.
My lords has it at page 18.
Yes.
Not to the inside the toilet, to the extent that to
Right.
that. My lords, they came to me till toilet and controlling me there itself. Also doing body gestures when I go for water also. My personal rights are violated. I understood from security that Shivani arranged and Shivani commended them, the poor security, to capture and control everything. Then, my lords, 8 p.m., second respondent was asked to leave the office premises as it was beyond office hours, but second respondent refused to leave until her laptop was given to her. That's a company laptop, my lords. But she refused to leave. 9 p.m., she writes this mail, my lords, at 9 p.m. Please notice the remarks in column number 5 first, my lords, page 20 only. Page 20 for a minute, the remarks may be noticed, my lords.
Yes,
How
sir.
this change of version, she starts from 9 p.m.
Yes.
This is where for the first time she says outraging modesty. Page 20, which is serial number 23.
When was she terminated?
She was much later, my lords, much later. Her termination was in June, 19th June, much later. My lords,
19th June?
June.
So these things happen in April.
This is in April. This happened in April. So, my lords, this mail at 9 p.m. may be noticed, my lords. How the change that she gives here at 9 p.m. to say it is a case of outraging my modesty. Then, my lords, please notice thereafter what happened after that, my lords. She was refusing to leave the premises at 1:15 a.m. This is 19th early morning, my lords. At page 23, 19/4/2024, 1:15 a.m., the company called the police to try
When is that incident said to have happened? The taking of the laptop and
between 5 to 5:20 p.m.
of
18th.
18th.
18/4 2024 incident between 5 p.m. to 5:20 p.m. and all these mails are after that. 9 p.m. my lords, we get this mail she gives a change to say it is a case of outraging the modesty. Please notice she doesn't leave the office premises. 1:15 company had to call the police to make the second respondent leave the office premises at night, my lords. Since the second respondent was refusing to leave the workplace, continued to create ruckus, affecting the office environment, Shiv Kumar called the police twice by dialing number 100 and was then connected to the Bhairapnahalli police station, spoke to the police personnel, after which police came at 1:15 a.m. on 19/4/2024. The presence of the police was captured in the CCTV footage and requesting her to return to her residence. The second respondent, however, was abusive to the police personnel, refused to leave the workplace. The police personnel left the workplace at 2 a.m. on 19/4/2024. Second respondent continued to be in the premises till 6 a.m. on the next day. She exited from the workplace. That's captured in the CCTV camera. Next morning, my lord, she leaves. Then, my lords, all that is there in her own mail, follow-up mail, which is there, that she's left the premises. Then the next relevant aspect is, my lords, please notice page 29 at 12:03 a.m. She herself says they have called the police to the company premises. My lords, gets page 29.
Yes.
My lords, 19/4/2024. Hi, David. Now, Ramanna Murthy Shivkumar called police and threatening me. What is this? Then, my lords, on the next page, 1:43 a.m., respected police officer asked me to provide access at door while leaving. I have tried to give access. Surprisingly, my door access got blocked. Actually, I know this before the incident. 4:07 a.m. Hi, David. I was there in office 18th April 10:30 IST to 19th April 6 a.m. without food, water, sleep, and passing urine. I'm fully down with high fever, dehydration issues, and even I'm unable to walk. On top of that, Ramanna Murthy, Shivakumar, security guards, and Shivani threatening me with the help of police team. My lords should get that, my lords, at page 31.
Yes.
Then, my lords, the company then goes to the police station, gives a complaint. My lords, it's serial number 25 at page 32. 19/4/2024, company filed a complaint before Bhairapnahalli police station. On the same day, NCR was issued to the company. My lords, page number is page 227 to 229, my lords. Is the page number of that complaint and
All right.
NCR. My lords, then, my lords,
You have to speed up.
yeah, my lords,
Yes.
next, after 6 days comes her complaint.
Yes.
On 24/4, she gives a complaint of 354 and 506 against A1 and A2 who are in US and the rest of the personnel here. Now, my
No,
lords,
there are two people who are alleged to have touched her.
my lords,
uh,
that
That
lady,
is Shiv Kumar and,
no, Shivkumar came later, only Shivani. She says, my lords,
no,
please
who
don't-
has? One minute.
Gautam Ramamurthy.
I'm
Ah,
sorry,
yes.
that was later, my lords.
One
Please-
minute. No,
Please
no, one-
notice at 5
And
itself,
Sangam.
my
One
lords.
minute, sir, 1 minute. Now come to page 20 of your synopsis.
Please, my lords. 9 p.m. My lords is looking at the
I'm
email
looking
at
at
9
9
p.m.
PM.
Please
right?
notice,
1 minute, sir. I'm just asking. Shiv Kumar and Shivani, so and so, and repeating the same. He took my laptop. So Shivani, of course, is a lady. And Shiv Kumar who took the laptop forcibly in the presence of security and was still experiencing so and so. Now Shivani is telling. So the allegation is against Shiv Kumar.
please notice 14, page 14, my lords. 5:20 p.m. Serial number 17, page 14.
Uh,
My lords, get set, my lords.
1 minute. Forcefully took my laptop and laptop had already been taken.
Shivani Gupta
Hmm.
forcefully took my laptop and forcing me to leave the floor. When the incident has just occurred, 5:20 p.m. 9 o'clock, my lords, how her version changes, adding Shiv Kumar and Shivani. Because
Came and
probably
Came and repeating the same situation in the afternoon. They took my forcibly by keeping hand. Oh, afternoon they took forcibly.
that
All right.
5:20, my lords, 5 in the 5:20 agid incident.
I thought.
Iddu 9
So
o'clock.
incident is, it is not happened at 9 PM.
No. 5 to 5:20 p.m.
All right.
My lords, now the short point would be, my lords, 354. 354, assault or force. In this whole sequence,
All right. Yes, madam.
Yes, my lords. My lords, kind.
judgments have already given of my
Fine.
lords.
Yes.
Yes. My
Those are
lords may-
354A.
Yes. But here, my lords had pointed out, Mohammed Ali has been reading in between the lines, that is what is relied upon.
Yes, my lords may just see the complaint. I also made a list of dates and events. I'm
Please.
giving it to my lords. I'm not going to labor through it.
Hmm.
Yes, my lords may see the
Better.
complaint. And
Please.
the relevant page is at page 39.
Hmm.
Now, I'm going to finish it quickly. I want to pause here because the whole initial bit that my friend said, oh, she was misbehaving. If I am misbehaving, the court can send me out as an analogy, etc. I will not address that. I mean, because that will just take up more time. My submission is any person may have been being misbehaving or non-misbehaving. The issue here is of 354.
Yes.
So 354 cannot be a response to someone misbehaving. If someone is misbehaving, you can take appropriate action. So for that reason, I'm not taking my lords into the whole PIP issue, though I fully disagree. I'm not taking
That's
my
all
lords.
right. That is
Yes. That is not of
work hazard.
exactly.
Yes.
That may be whatever may be their work-related issues. Now, my lords may see the complaint.
Hmm.
In the afternoon, at page 39, I will just read out the relevant bits.
Yes.
She had given the complaint initially on 19th. That is immediately on the day she was out.
Yes.
And then ultimately it was registered only on 24th because she went from one DCP
So that's
to
so,
another.
don't
Yes.
worry about that.
Now, page 39, kindly see.
Yes.
Fourth para, around 3:30 p.m.
Yes.
May I read?
Yes.
Around 3:30 p.m. IST on 18th April, Shivani Gupta came to my desk and forced me to come to a private room. At that time, I was into a scheduling meeting, and that was between 3 to 4:30. I guess Shivani Gupta knows about that meeting. I am, etc., etc. Then, my lords, let me come to the fifth line. I mentioned all of this. I've experienced the same situation with Sangamesh, Gudiyappa, and Shivakumar. They forced me to join the unplanned, unscheduled meeting and started harassing and threatening me off the record as there was no scheduled meeting. The same way, Shivani Gupta forced me to come into a private room to harass and threaten me. Shivani Gupta was ready to schedule a meeting. When I requested, she left from my workstation and blocked my account completely to access and communicate my resources. When I reached out to the IT team to unblock the account, they said that the HR team guided them to block my account, and IT team said, please go to HR. Again, immediately, Shivakumar, Shivani, and Ramamurthy came to my desk and in front of all the employees took my laptop. When I held the laptop to my breast by keeping a hand on my breast, they tried to take my phone, but I took hard efforts to keep it with me. I started crying when they touched my breast.
So
Heavy.
this is against three.
Yes.
Gautam Ramamurthy, Shivakumar, and Shivani Gupta. All right.
Yes.
What has this David, Marco, Sangamesh, security officer to do with
Yes,
354
security
allegations?
also is there.
354
Security-
allegation gave, how is that? How are they connected?
No, there is criminal intimidation allegations. So now the security guard is there. Can I just read out? With
Yes.
heavy force, Shivani took
No,
my...
these three,
Yes,
yes, they have indulged, is
Yes.
what you say.
yes,
Yes.
yes, that is what I'm saying.
That is at what time?
My lords, all of this happened from about 3:30, 4 o'clock onwards.
Laptop was taken at what time?
After that, around that time.
Why you did not complain of that when you initially sent a mail that laptop is forcefully taken?
Yes,
Why you did not say that they have inappropriately touched?
lords, there are innumerable judgments which say that even the complaint, if it does not have full details, my lord, she is
No,
sitting there.
Complaint is not an encyclopedia. FIR is not an encyclopedia. No problem. But there should be basic things.
Of course. And in
So
fact,
in your mail, not in
No,
the complaint,
I have
madam.
sent mails. I have sent mails. I will show out my
In the
mails.
first mail, if you had been inappropriately touched,
Yes.
why you did not complain in the first mail?
My lords, she is someone who is being in that situation. What is anybody's mental state? You are writing, you are
Oh,
sending
maybe.
out emails. you are
According to
sending out
you,
on the phone.
According to you, first, Shivani Gupta took away your laptop.
No.
So laptop is taken.
No, may I suggest?
No,
The-
that's your mail.
That may be one of the mails.
No,
She
no.
has sent at least about 15 mails.
No, that's later. Now
Maybe
at
later, yes.
what time is that? 3:30 p.m. is it?
In fact,
5:20 PM in the evening, you
Yes.
send a mail that Shivani Gupta has taken away your laptop.
in fact, she says,
Hmm.
Shivani Gupta took my personal belongings, including cash wallet.
All right.
Then she says that I do not understand. And then at 6:50, she said she's even to use the washroom, the security guard. That's why she's mentioned the
All
security
right.
guards.
All
She's
right.
not letting her use the washroom, or they're following her outside the washroom.
Fair enough. Hmm.
Thereafter, from, in fact,
Was the laptop again taken?
my
Was it taken again?
the phone was taken,
No.
given back and taken again.
That's all right.
Yes.
Laptop was taken again. No.
I'm not too
No,
sure.
it's
whether
your
laptop
mail.
was
Your
taken. Yes.
mail, because laptop was already taken.
Yes. At the time, the laptop and phone were grabbed from her
Yes. By whom?
by all
Shivani
three of
Gupta.
them. The
By,
would-
because your 5:20 PM laptop taking email says it is Shivani Gupta.
she may have, my lords, I want to make a submission.
Hmm.
She makes it in one email or maybe two emails. She says Shivani Gupta forcefully took the laptop. But just because she does not mention, later on, she continuously mentioned, and later on is not after 3-4 days.
That's all right.
It is
But
only
laptop
after a couple of
incident
hours.
has already happened.
Yes, no, it has not already happened. She's
Huh?
still in the
No, no, no. That's all right. Laptop taking incident has already happened.
One part of the incident has happened.
No, that's the only part of the incident.
No, there are two parts. My submission is two parts. One
Did
is
they come and take the laptop again?
I'm going by the documents. I'm going by the
Even I'm going by your mail.
Yes. Now, my lords, I'm saying there are two parts to it. One is when at the time of grabbing the laptop, she was inappropriately touched
By whom?
by three of them.
Where is your mention about the grabbing of, when
Yes.
the laptop was grabbed at 5:20 PM, you send a mail, my laptop is grabbed
Yes.
by Shivani Gupta.
Maybe because she was one of them. I may not. My
Hey, you
lord.
should have mentioned, most important thing, you should have mentioned those two have touched you
It is
inappropriately.
mentioned. It is mentioned. My lord.
4 hours later.
My lord, it's not even 4 hours later. It's
9
only
PM.
3 hours later.
9 PM.
Whatever. My lord, somebody is in a situation where you are kept there, your phone. I want to just point out, her bag is taken. Her bag has all her
And what
bank
are these two to do, who are in United States?
My
Is
lord,
it not an abuse of the process of the law?
my lords, on criminal
Dragging them
intimidation,
also in the crime?
my lords may say that 354, they were not there.
Then
They
how
were
can,
not
how can you drag them into these
Not
proceedings?
criminal intimidation. They have,
What intimidation?
I mean, she also.
You see 503, the ingredients of 506, what is there?
My
That
lords,
should be present.
my lords.
How have they intimidated you?
Fact, my lords.
Asking you to do some work is intimidation?
No, I'm not
Then
raising
what?
that issue. Now, my lords, my submission is at least the people with whom I've made allegations. Against those clear allegations. Let me, my lords, may kindly for a moment.
So
Kindly,
clearly this 1, 2 and 6 have nothing to do with it. In your complaint at page 37,
yes,
yes.
my complaint has.
David Korst,
Yes.
Marco, and this Sangamesh.
Ones who were
Gudiyappa.
there, my lords are right. The ones who were there
Hmm.
are 3, 4, 5 and
Why
6.
did you drag the others?
My lords, I have put their names. I have,
For 354 and 506, why did you drag the others?
my lords.
Were they there
354,
or were they, did they indulge in anything that would become 354?
the reason, my lords, in the complaint sections are not.
That's all right.
See, in the
No problem.
complaint sections are not.
Sexual
Sections
harassment
are
is
put-
alleged against them also.
Sections are put by the police.
It's all right.
Strictly speaking.
Harassment is told by you, they have put
Yes. Now,
354.
strictly speaking, perhaps why she has put them is because 354A, which is sexual harassment
A.
at the workplace, which is not included.
A is
It
not
is
there.
not included. The police may not have put it. But in the event workplace related harassment is there, she has also put their names. Now, my lords, in this event, 3, 4, 5, 6, and 7 were all there, which is there in my complaint. Maybe 1 and 2 were not there. That I have also not stated that they were there. They were not there. Now, my lords, kindly see in my objections.
Hmm.
May I request my lords to see my objections?
Hmm.
In my objections, kindly see from page 26 onwards.
Hmm.
Page 26.
Hmm.
This is an email of, again, 18th April, 9:45 PM.
Yes.
Where 26.
Hmm.
Yes. 9:45 PM, 18th April. I'm still there. She writes, "Hi Kendra, looking forward to your kind stand on the below email. Can you check CCTV footage?" Hi David, I expected a response from you. I'm still in office. It's 9:30 p.m. in India. I can't leave the floor without the laptop. They had taken away. My friend says, I'm asking them to go. She's not going.
That's all
She
right.
wants to be there.
Yes,
My
yes.
belongings are taken away. How can I leave without my belongings? Then she says, last time you were in India in the meeting, you have mentioned about women's leadership
All
opportunity,
right,
etc.
I've seen that. Also
Also,
get the recording.
Recording, she writes the incident. I lost my professional, personal, social status, and due to this disgusting situation, etc. She writes all that. Then in fact, in the third para, she writes that I'm very sorry to ask you, but can I request you to check with your mother and on the breast issue? Anyway, she writes all that. Then, my lords, the next page, at page 28. 28 is again at 11:20. She writes again saying, hello, David, security team harassed me when I went to the toilet. I was unable. I sent a recording of the harassment she was facing at the hands of the security guard. And then she says, David and others, I'm unable to attach here, etc. And she says how she was not able to use the restroom. Thereafter, again at, my lords, at page 30, at page 30, at 1:43, she says, now Ramamurthy, Shivakumar have called the police. They call the police. Police come, based perhaps on their NCR, they go back. Then I request the police, please give me all my belongings back so that I can go. In fact, my belongings have my purse, wallet, jewelry, cash, and laptop. And thereafter, at 4:07 on 19th April, I called them, they came, and then when they tried to go out, her access door was locked. And then at about 5:36, she left. After she left, she goes and files a complaint. And when the complaint is filed, she writes a detailed email, which is exactly on the same day, on 19th. Now, my submission, my lords, is perhaps one mail here or there may not have, those emails are one line. She is not writing.
That will answer about whom you have said. But why do you drag others?
My lords may say 1 and 2 may not be there.
That we'll see.
My lords
What
may
I'll
say 1
say,
and
I'll
2 may
say.
not. Yes, of course, we are in my lords.
Yes, yes.
Now, my lords, I just want to submit one set of decisions in which just one judgment I will go through. Madam. Let's give it to the other side. There are two decisions, Rupan Diol Bajaj, which my lords are familiar with, that I will not labor on. The first decision is a 2017 SPS Rathod versus CBI. Here, the ingredients of 354. And if my lords may look at, para 42 onwards, internal page, ink page 22.
Right.
Para 42.
What is necessary is what is said. 354, para 42.
Yes.
Yes.
What is the ingredients of the offense?
Yes,
What does
yes.
354 mean? In order to constitute the offense under 354, mere knowledge that the modesty of a woman is likely to be outraged is sufficient without any deliberate intention of having such outrage alone for its object. There is no abstract conception of modesty that can apply to all cases. A careful approach. My lords, I wanted to submit all of this to show that ultimately 4 of the people and the security guards, of course, their names are not here.
The security guard has not touched you.
No, but the restriction on using the restroom, my lord,
That
is
we'll
that
see.
not,
That will.
is that not also
That 354, we'll see.
for that reason, 354, my submission is that there are 2 parts to it. One is the incident which happened where she was
We
inappropriately
can't
touched.
cut it too fine. We'll see what's to be.
Yes. So my submission is that
Heard,
that also
reserved.
amounts to.
Wash committee is there or not?
It's a
Now, my lords, they have submitted in a subsequent memo their letters to the government saying that we have a ICC committee. When I have submitted a letter to the State Women's Commission has sent them a letter, please constitute the ICC committee, which I have submitted. They have not sent a letter to them. If they have submitted, if they already have an ICC, in any event, my lords, an ICC is not mandatory.
Existence of ICC is not, no, it's condition precedent for you to go 354. I have myself held.
My lords have said, even in the judgment that my friend has submitted,
In
my
that
lords have
judgment
said
only, in that Sabrina
exactly
something.
that
yes.
ICC is one.
Whether
factor.
ICC is there or not, independent of that, you can always,
Exactly.
only for clarification. I asked.
Even in the judgment that of my lords have in fact confirmed the complaint, dismissed the complaint only
Accused
against
number
others.
7.
Yes, yes, where there were clear allegations. So my lords, at least to the extent
We'll
that where
see.
there are clear
We'll see.
allegations, my lords.
Yes.
Ultimately, thereafter, she is terminated. And I want to point out in the termination letter, not a whisper is made about any allegation of any
No,
non-performance.
that will become a problem. It should be termination simpliciter.
No. What
Otherwise, it
my
becomes stigmatic.
allegations are made that she was becoming a difficult person. My lords,
That's it.
350.
See, we are dealing with 354, madam, not the
Exactly.
termination.
Exactly.
We'll deal with.
That
Yes.
is, that is my.
Heard reserved. Further investigation qua these petitioners till the disposal of the petition shall remain stayed.
My lords, that.
No,
may-
I've reserved it. It's not correct. I've heard it and reserved it. It's not correct that I don't protect them till then. Because 1 and 2 are there.
That will be
then-
limited to 1 and 2.
No.
Well, is
I
it-
can't do that. I can't do that.
My lords, 1 and 2 have not even filed petitions. Let it be limited to 1 and 2.
Who has filed
But it's
petition
from
now?
3 onwards.
Not even
3
filed.
onwards.
Who has filed?
From accused number 3, my lords. From
Yes, 1
accused
and 2
number
have
3,
not
the rest
even
of them.
filed.
That's all right. We'll see. I've reserved it. It's all right.
My lords,
We'll
we
pronounce
have,
it. Yes.
we have absolutely, my lords have reserved it. There's no difficulty
So
with that.
generally, madam, when we hear and reserve it, it should not frustrate the order that I pass.
But
It should not render everything fait accompli by the time I pass the
certainly,
order.
but
That is why
normally
to protect
when-
this, to preserve the status quo, this is the course that is necessary.
my only submission is, my lords, that when there has been no interim order or status quo,
all
any
right.
such finding,
That's all.
normally when a matter is reserved, the same status
No,
continues.
if by the time I pronounce, investigation would be over.
My lords,
Then-
1 and 2 are not, if that is.
That's all right. No.
1 and 2 are not even
Imagine,
here.
you think of a situation like that. My order should not be rendered fait accompli at all.
My only concern, my lords, my only submission is that there is an incident
That
where
I will
there
answer all
has
that.
been an outraging of
I
modesty.
will
Let that
an-
not be
I
minimized.
will answer all that.
That should not be minimized, my lords. We are not here in a situation.
It should neither be minimized, not blown out of proportion.
course.
We will answer it.
There is, but my lords, are we saying that a
I have not
complainant
said
is
anything.
blowing it out? That's
I have
all.
not said anything. Yes.
Till then, let whatever
no, no,
status quo, my lord.
Correct. To preserve status quo, it is necessary. And not that I'll be taking 1 year.
No, we
Yes.
have no, we have
Yes.
no
So do it.
worry about my lords passing orders. That is not the
We'll do it.
concern. But
Immediate- Immediately after the vacation, I'll pronounce it.
my lords, that we have no,
Yes.
we have no concern.
Deeply obliged.
Yes.
Safe.
Bill number 12.
I appear for the petitioner. Forensic,
Then forensic,
this is 304A,
FSL.
FSL.
KNF.
This is that swimming pool electrocution death.
The forensic examiner, my lord's initial report says there's no opinion as to the cause of death.
Early the FN.
I'm
Page
getting
40,
it, man.
Hmm?
I'm getting the report.
Where is the report?
I'm getting it, man.
Report.
Pass over, Mandla. Pass over, yes. Next.
Petitioners.
The Buds Act, my lords, under the Buds Act, section 27 requires that the regulator should initiate the
No,
process.
no, no, no.
Yes, my lords.
After vacation, yes, list after vacation.
My lords, here is an individual who has initiated the process and a charge sheet is filed. My lord's judgment, my lords.
Dharwadadala,
Here
That
is here is judgment.
that
It was
is-
coordinate
that is
bench.
incorrect, yes.
Coordinate bench should be there.
My judgment is wrong,
27 only.
yes.
27 reads like that.
25 Nodi.
Sorry, 20. Thought the two judgments also say, my lords, 27, it has to be the regulator.
Yes, comment.
Exception is, my lords,
Let it come after vacation.
ಒಂದು protection ಇಲ್ಲ.
No, 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 yes. Buds Act alilla.
But exactly, because this is done by an individual. And she says she's
Give me the judgment, my judgment.
both. Are.
I'll distinguish myself, yes.
The copy.
Dharwadadalva? No, this is Aitu. Where is my judgment?
The copy.
That's the one.
No, sir, there is original judgment, Dharwadadondide.
Not this Vijay Mohan.
Santosh Kumar versus so and so. Santosh Kumar wala, ಅದ್ರಲ್ಲಿ ಇಲ್ಲ ಹಾಗೆ.
Because Vijay
No, none of
Mohan-
these, none of these.
So, my
in
lord,
which senior counsel Ravi Shankar had appeared. Yes, government look into these.
Copy ಕೊಡಿ.
ನೀವು ನೋಡಿಲ್ವಾ ಇದನ್ನ?
Copy.
ಅಲ್ಲ, ಕಾಪಿ ಇಲ್ವಾ ನಿಮ್ಮ ಹತ್ರ? Petition copy ಇಲ್ವಾ?
petition.
Petition
copy.
copy.
Then you should know what is this.
CFT.
Either I will grant stay in every case. Yes, list on 14th. In the fresh matters list.
Section.
Till then, yes, nothing. ಇದು ಮೊನ್ನೆನೆ ಕೊಡ್ತಾ ಇದ್ದೇನೆ. Heard the learned senior counsel sounds. Next.
Cancellation of bail, my lord.
Nishit.
In this case, my lord,
For
initially, my lord,
two
he
minutes.
is approach this one will go to under the 482, my lord.
ಹಾ, ನಂದೇ ಆರ್ಡರ್ ಅಲ್ವಾ?
Also, that my lord, under the 188, he has stated that 180 is applicable. This lordship rightly held that it is not applicable.
ಯಾವುದು?
Initially, my lord, without.
No, I have, where is my order?
I produced, my lord. It is in page number 52.
ಹಾ,
The petitioner, my lord, without getting bail, my lord, he initially approached this lordship, my lord.
I dismissed it.
Dismissed it as saying that investigation necessary.
Correct.
Thereafter, my lord, he filed.
ಅಲ್ಲ, what did I dismiss as?
Investigation gone, 188 is not applicable and failed.
Ah, it was a bar, yes,
That's
I have,
rightly-
I have held so.
rightly-
Everything has happened here.
Correct, correct.
All right.
Now, my lord, now this is completely different, my lord. I applied for the bail, my lord. For the reason, it's a.
One
bail-
minute.
bailable
Where is your application for bail? No. ಈಗ bail ಮಾತ್ರ ಇರೋದಿಲ್ಲಿ?
ಹೌದು. Question is that, my lord, bail, my lord, I'll summarize the gist, my lord. I filed a bail application, my lord, under 438, my lord, before decision. It was got rejected.
ಆಯ್ತು.
Then I surrendered before the trial court, my lord.
All right.
I obtained a regular bail.
All right.
Against that order, state has filed a revision,
All right.
which was allowed and my bail is cancelled. Against that order, I filed this petition before this.
The
court.
revision is
Also,
not maintainable.
That is the only one submission.
Why was the bail cancelled?
Bail was cancelled on the ground that I have not stated the rejection of the 482 petition before this honorable court, my lord.
Huh.
As
Why
well as
did, why did you not state all that?
In fact, my lord, that 482, my lord, on merits of the case, my lord. Now, my lord, all the case, the two sections are bailable in nature, my lord.
Charge sheet ಆಗಿದೆ ಈಗ?
Investigation, I went to the police station 22 times for the investigation purpose, my lord. Charge sheet not at file, my lord.
My lord, charge sheet not
Now,
at file.
charge sheet ಬಿಟ್ಟಾಕಿ.
Please, my lord,
He applies bail.
please,
Bail is granted.
please.
Divisional court sets aside the bail on the score that he has not divulged the dismissal. What bearing it has on bail matter?
My lord, bail matter, my lord, he has surrendered before the court. On the same day, he was released on bail. And my lord, your lordship may kindly see, learned session judge says there is no application of mine by the learned magistrate. My lord, it is a
It
cryptic
is sent
order.
back, is it?
No, it's
Then-
cancelled. Bail is
Cancel the bail. My lord, the reasoned order, my lord.
Where is the order granting bail?
It is
The in page number,
page number
29,
29, my
my
lord.
lord.
29, starting 29.
my lord, only one,
Relevant
Bail
para-
ಕೊಟ್ಟಿರೋದು ಎಲ್ಲಿದೆ order?
ಅದೇ,
Page number
First
30, my
order.
lord. Page number 30,
30.
30, my lord. It's a maximum punishment is 7 years, my lord. Except two section, all other is bailable nature.
well, 31 it starts, my lord, reasoning. Only, that all are, my lord, facts of the case. 31,
Accused
my
shall
lord,
appear before 31.
Ah,
Peruse
31.
the file. heard
Peruse the
both
file.
sides.
may I read, my lord, peruse the file, case file. The offences alleged against the accused is non-bailable, but it is not punishable with death or imprisonment of life. The accused is ready to furnish surety, so and so.
We'll do one thing.
It's
We'll
a
set
case-
aside both and send it back to the court.
Please, under 437 also there is a provision, 439.
Whatever you want, if this is not reasoned or this is,
But because learned
we'll
section,
set aside both and send it back.
Please.
First,
It meant with regard to not maintainable,
Huh?
not maintainable.
my lord, it is,
we'll
no, my lord, it is not an interlocutory order.
We'll not
It is-
get into that issue.
Yes,
Much-
Yes.
because it is an intermediate order, my lord, as held by the honorable Apex Court.
I have
Other
myself
by
felt,
case-
sir, it is not
Please.
interlocutory, it is intermediary.
Please.
Yes. Yes, Jagdish, ನಿಮ್ದೇನಿದೆಯಾ?
ಅಲ್ಲ, in fact, my lord,
ಏನಾದ್ರು ಬರಿಬೇಕಲ್ಲ ಬೇಲ್ ಕೊಡ್ಬೇಕು.
They should have filed a different application, but they filed a wrong application. Doesn't matter.
ಅಲ್ಲ, ಡಿಫರೆಂಟ್ ಅಪ್ಲಿಕೇಶನ್ ಹಾಕ್ಬೇಕಾಗಿತ್ತು ಕ್ಯಾನ್ಸಲೇಷನ್ಗೆ.
Either 437 clause 5 or 439 clause 2.
Anyway, we'll set aside both and send it back.
read with 397 ಅಂತ ಹಾಕಿರೋದು.
Huh?
397 more.
436-2, read with 397 petition.
Yes. The petitioner is before this court calling in question an order dated 17/8/2024 passed in criminal revision petition 34 of 2024, whereby the order by which the petitioner was enlarged on bail stood cancelled. The petitioner heard sounds. The petitioner was before this court in criminal petition 4351 of 2023, which comes to be dismissed by an order dated 12th July 2023. The reason for dismissal can be gathered from the following paragraphs. Para 7(2). This court dismissed the petition on the score that investigation was imperative and the investigation would continue against the petitioner. The issue that what has driven the petitioner to this court in the subject petition at this juncture is not an order, not anything concerned with the order dated 12 July 2023 quoted supra. The petitioner is said to have appeared before the concerned court and he is enlarged on bail.
Before that, he filed anticipatory bail. Before that, he filed 438 application.
That is dismissed.
That is dismissed.
The
Before 1 week.
petitioner appears, a petitioner prefers an application seeking anticipatory bail which comes to be rejected, after which he is said to have surrendered before the concerned court and the concerned court on the very day grants him regular bail. This is challenged by the state.
State.
This is challenged by the state by preferring a criminal revision petition in Criminal Revision Petition 34 of 2024. The Court of Session, the concerned court answering Criminal Revision Petition 34 of 2024 sets aside the order granting bail on the score that there is no reason to grant bail,
Also suppression of that.
Huh?
And also suppression by the
Suppression ಅಂತ ಹೇಳಿದೆ ಇಲ್ಲಿ
Lord.
ಏನಿಲ್ಲ ಇಲ್ಲಿ ಅವ್ರು ಹೇಳಿದ್ರೆ ತಾನೆ ಗೊತ್ತಾಗುತ್ತೆ.
There is judgment. They have quoted 2 judgments of my Lord. Your Lordship may kindly see.
ಅದಲ್ಲ ಸರ್, ಒರಿಜಿನಲ್ ಆರ್ಡರ್ಲಿ.
Original order.
The order granting bail reads as follows. The reasons to grant bail reads as follows, page 31 to 32. This is challenged on the ground that there is no reason indicated, a reason to grant bail to the petitioner. In the revision petition, the state would take a contention that there is material suppression on the part of the petitioner while applying for regular bail before the concerned court, as the order of this court was not brought to the notice of the concerned court. On this reason, as also the reason that the order granting bail did not contain any reason to so grant bail, the revisional court sets aside the order granting bail. Both these, the revisional order is what is challenged in the case at hand. A perusal at the order granting bail would clearly indicate that it was bereft of reasons, bald and laconic. Perhaps for the reason that the petitioner did not bring it to the notice of the concerned court, the order passed by this court supra. The issue now is the revisional court did not have jurisdiction to entertain the application. In the light of the order granting bail being bereft of reasons and the fact of the contention that the revisional court did not have jurisdiction to entertain the petition and the judgments of this court or the apex court being on both the sides, I deem it appropriate to remit the matter back to the concerned court, i.e. the court empowered to grant bail to the petitioner. How court adu?
Lord, in the Court of Traditional Civil Judge and JMF State Udupi.
So and so.
Itinerary at Brahmavan.
ಎಲ್ಲಿ ಸಿಗುತ್ತದು?
Lord, in page 29.
20? Madam, same court ಇದು. Page 29, circle ಮಾಡಿದೆ. So and so. To consider the application of the petitioner, bearing in mind the observations made in the course of the order and pass necessary orders within 1 week from the date of receipt of the copy of this order.
Please.
Yes.
Disposal. If he, my Lord, this order is not sustained, he has to again go to prison, my Lord. Obviously, my Lord. Interim.
ಅಲ್ಲಿ ಆಗ್ಲಿ.
Interim protection may be till disposal of that.
No, disposal till you approach, you should seek that before that court. I'll release it today itself, today or tomorrow. Yes.
Highly obliged.
ಆ ಕೋರ್ಟಲ್ಲಿ ಏನು ಇಂಟ್ರೊಡಕ್ಷನ್ ಕೇಳಿದ್ರೆ ಕೇಳ್ಕೊಳ್ಳಿ.
Till disposal, my Lord, otherwise what happens?
That court will decide. Yes. You apply before that court, ತೊಂದರೆ ಆದ್ರೆ ಮತ್ತೆ ಬನ್ನಿ. But you should not have suppressed everything. It's not correct. ಅಲ್ಲ ನೀವಲ್ಲ ಬಿಡಿ. You are not there. ಪಾರ್ಟಿ ಏನ್ ಮಾಡಕ್ಕಾಗಲ್ಲ, but should not do that.
Normally 437 ಅಲ್ಲಿ ಬೆಲೆ normally 7 years ಇದ್ರೆ ಅಲ್ಲಿ
ಏನದು ಒಂದು ಎರಡು ಸೆಂಟೆನ್ಸ್ ಬರ್ದಿಲ್ಲ.
ಎರಡು ದಿವಸ ಒಳಗಡೆ ಕೂತಿದ್ದು ಅವ್ರಿಗೂ ಬೇಜಾರಿರ್ಲಿಲ್ಲ.
Gravity of
ನಾನು ಅದೇ ಅವ್ರಿಗೆ ಹೇಳಿದೆ, 2 ದಿವಸ ಒಳಗಡೆ ಕೂತಿದ್ದು ಇಷ್ಟು ಸಮಸ್ಯೆ ಇರ್ತಿರ್ಲಿಲ್ಲ ಅಂತ ಹೇಳಿ. ಕೋರ್ಟ್ನವ್ರು ಅಲ್ಲಿ ಆ ಜಡ್ಜ್ ಏನಾಗಿದೆ ಅಂತ ಹೇಳಿದ್ರೆ ಸೇಮ್ ಡೇಸ್ ಬಿಡುದು, 7 years ಮ್ಯಾಕ್ಸಿಮಮ್ ಪನಿಷ್ಮೆಂಟ್ ಇದ್ರೆ ಅವತ್ತೇ ಬಿಡುದು.
ನಾನು ಆ ಲಾಸ್ಟ್ ಟೈಮ್ ಹೇಳಿದೆ ಸೆಟಲ್ ಮಾಡ್ಕೊಳಕ್ ಆಗಲ್ವಾ ಆಯ್ತಾ.
Is gravity of the offense, my lord, London
ಅಲ್ಲ, that I have considered and dismissed it. Leave it. Because it was misappropriation, I have dismissed it.
Please.
Alleged misappropriation.
Oblige, no. Wait.
Much obliged.
And Nishit, don't feel that I have said something against you. I'll never do that. Separation is by the petitioner, not the counsel for the petition.
ನಾವು ಹೇಳಿದ್ದು ಹಾಗೆ. Special by the
ನಾನು ಹೇಳಿದ್ದು
petitioner ಅಂತ
ಅದಕ್ಕೆ.
ಹೇಳಿದ್ದು.
ಆರ್ಡರ್ ಸಪ್ರೆಸ್ ಮಾಡಿ ತಗೊಂಡಿದೆ ಅಂತ ತಾವು ಹೇಳಿದ್ರೆ.
Bail ತಗೊಂಡ್ರದ್ suppress ಮಾಡಿ ಅಂತ.
ತಾವು ಹೇಳುವಾಗ interim
That
order
may
ತಗೊಂಡಿದೆ.
have, I have,
Evening, my lord,
not
about
against.
5:15.
ಹೌದು.
It's not today I'm seeing you, yes, all right.
He called me many times. I told him it is not for you.
No,
it's
no,
for
no.
the petition.
We'll never do all that against counsels unless it is very grave.
ಹೇಳಿದ್ರೆ ನಾನು ಇಂಟ್ರಿ ಮಾಡಿ ತಗೊಂಡು ಸಪ್ರೆಸ್ ಮಾಡಿ ತಗೊಂಡಿದ್ದೆ ಅಂತ ತಮ್ಮ
Bail ತಗೊಂಡ್ರದ್ suppress ಮಾಡಿ ತಗೊಂಡಿದ್ದು ಅಂತ. Yes.
Oblige.
And for the petitioner, the offense under section 306.
Papers,
Please, my lords.
ಕೊಡಿ. Monday fresh matters list. Next. Papers ಕೊಡಿ.
Bank transaction were found.
Bank
Transaction, your petitioner account transfer ಆಗಿರೋದು.
ಬ್ಯಾಂಕ್ ಟ್ರಾನ್ಸಾಕ್ಷನ್ ಏನಾಗುತ್ತೆ?
Financial transaction.
Anyway, Monday ಕೊಡೋಣ. Let me also see the papers. Next.
Crime for the petitioners.
It's a matter that came up day before yesterday on application of mine while taking cognizance. I saw time.
ಈಗ now you have got
Yes,
whole lot of judgments?
I've got.
No, sir.
Because probably, my lords, if this contention is to be accepted, then in 80% of all the matters,
Correct.
it will have
It
to.
should go.
I will
It
point out.
should go, sir.
My lords, I will point out that is.
These courts cannot play with these provisions to say that we will do it just like that. ಕೊಟ್ಬಿಡಿ ಎಲ್ಲ all judgments ಕೊಡಿ. Give it. Argument ಇಲ್ಲ, only law.
Argument, only on the law.
Only law. Give
Only
it,
on
give
the
it.
law.
Give the
My lords, I'll
judges.
quickly just show the
Yes,
judgments, my lords, because even my lord's judgment, 2 judgments I
Please,
put
please,
along
give
with
it, give it.
this.
Yes.
The distinction that is drawn between a private complaint and cognizance being taken and with a police report.
This is what private complaint.
No, it's on a police report.
ಅದಕ್ಕೆ ನಿಮಗೆ ಟೈಮ್ ಕೊಡಬಾರ್ದು. Yes.
ಅಲ್ಲ, ನಾನು ಕೊಟ್ಟ judgments ಎಲ್ಲ
Malad-
CBI ಕೇಸು,
They're
police
in all-
charge sheet.
I'm sorry, they're all,
paragraphs.
my lords, in all 7 judgments, starting with this Jagdish Ram, my lords, versus State of Rajasthan, 2004,
Yes.
relevant portion, paragraph 10,
Ah.
at my lords, page 6, paragraph 10.
Yes.
Then, my lords, the second judgment is Bhushan Kumar versus State, 2012 5 SCC 424. The relevant paragraph, my lords, is at paragraph 11 at page 13 and paragraph 18, my lords.
Yes.
It referred to in
My lords,
Vikas.
then,
Yes.
Referred to in Vikas.
yes.
Yes.
Then comes the next judgment, State of Gujarat versus Arfos. My lords has relied on this. I will point out, my lords, how my lords relied on this judgment.
2019.
2019-20.
Hassan Fatah.
Yes, my lords.
Yes.
In this, the relevant paragraphs, my lords. Paragraph 16 at page 25 and 25. Then, my lords, at page 27, paragraph 21 till 23, my lords, which we get at page 28. Everywhere, my lords, they show the difference between a private complaint and when it's on a police report. Thereafter, my lords, the next important judgment, I'm sorry, my lords, in that judgment, 23, ಮತ್ತೆ one more paragraph at 39 ಇದೆ, 39,
Yes.
which is at page 34. Then, my lords, in a criminal revision petition, the coordinate bench of our court, my lords, the very same contention now was taken in that case, my lords. I think my learned senior had appeared in that matter also, my lords. He took the same contention application of mind on a police report in Jayachandra's case. The relevant paragraph there, my lords, in Jayachandra's case is paragraph 14 at page 56, my lords. The court would say, no, insofar as police report, it is not required that you have to disclose a lot in it. Then, my lords, the next judgment
Yes.
is Pradeep Wadiyar. This is the most important.
Most important, 108.8. Yes.
Adರಲ್ಲಿ, my lords, Pradeep Odeyaರಲ್ಲಿ,
Pradeep Poder, paragraph 108.8.
ಅದಕ್ಕಿಂತ ಮೊದಲು paragraph 10.
No,
Poder-
ಅದು Pradeep Poder cognizance gene there is one issued.
ಹೌದು, ಆ
Uh,
issue ಅಲ್ಲಿ, my
related.
lords, paragraph
ಅದರಲ್ಲಿ
10.
conclusion is paragraph 108. ಅದರಲ್ಲಿ 108.8 ನೋಡಿ.
ಹೌದು, my lords, paragraph 11 ಅಲ್ಲಿ they extract the cognizance order. That is most relevant, my lords.
Yes.
My lords should get that at page 9.
ಅದರಲ್ಲೂ ಅಷ್ಟೇ ಏನೂ ಇರಲಿಲ್ಲ.
Yeah,
ಆ cognizance order if you want to see, Justice Michael Kunna ಅವ್ರ judgment ಅದು.
ಹೌದು.
He affirmed that.
Even in Pradeep Odeyar,
It's affirmed only.
they extract that, my lords.
Yes, yes.
They extract, my lords, ಒಂದೇ ಒಂದು ನಿಮಿಷ, page 95, paragraph 11 ಅಲ್ಲಿ,
ಹಾ,
what it says is, peruse the final report.
yes.
Cognizance is taken against accused 1 to 5. Register the case. Register the case and issue summons to 1 to 5, returnable by so and so. This is what it says in Pradeep Odeyar, and the contention taken was there is no application of mind. Now, answering that, my lords, in Pradeep Odeyar, they distinguish the two aspects. When it is on a private complaint, how the cognizance order and issuance of process should be. When it is on a private complaint, on a police report, how it should be. My lords, that commences from paragraph 85, my lords, page 132 ali.
Yes.
They deal with all the earlier rulings on this, my lords.
Yes.
Paragraph 85 in the 91 varege, my lords. The whole issue is covered. Then,
Yes,
my lords, following this,
Counsel, mark the paragraphs you're relying on.
ಅದರಲ್ಲಿ 3 judgment ಅವ್ರದ್ದು.
Give it.
More judgment, I can point out what is different. Our first judgment is on the basis of a private complaint. My lords, first judgment, private complaint. The last of the judgment, 306 ಅಲ್ಲಿ, it was a B report. B report ಮೇಲೆ 202 proceeding agi, then when there was issuance of process, there was no application of mind. That the court said is wrong. You have a B report with you, you do a 202 inquiry, and then you're going to be issuing process, you should show application of mind anta. Whereas in all these 7 judgments, my lords, which I am relying on, it is on the case of police reports, how it should be done. Even they have extracted, my lords, what's the cognizance taken. Now, my lords has extracted the cognizance taken. I'll point out my lords' judgment, my lords. 2 judgments of my lords. My lords, first is Ratan Babulal. My lords should get it at page 151.
Page 33 of my judgment. See page 34, the next page, I have said it, the perusal at the order of taking of cognizance does bear application of mind.
Absolutely.
So it is not applicable.
Absolutely.
Yes.
Then, my lords, the other judgment where my lords felt there's no application
That
of
was an
mind.
error because PC Act, that
Oh.
I was dealing with PC Act. So I have said so. The subsequent judgments of the Supreme Court are here. Yes, sir.
So, my
Anything
lords,
else? Sir?
now, as it stands, my lords, and kindly, what was read in our judgment was our cognizance order, my lords, page
52.
552. Please notice, my lords, I'll just read this, what has been taken as cognizance here. Peruse the charge sheet and all the documents submitted along with the charge sheet by the investigating agency. 552, my lords. On perusal of the same, this court is satisfied at this stage that prima facie offense has been committed by the accused as alleged. The charge sheet and its enclosed papers satisfies that there exists sufficient materials to proceed against the accused. Therefore, cognizance is taken under section 191B of CRPC for offences under section 418, 420, 465, 466, 120B against the accused persons. Office to register the case as criminal case against the accused for so and so and put up. Issue summons to the accused. So in my respectful submission, this is all that would be required in a police report for taking cognizance, my lords. My lords, I've placed all the judgments on this point. I leave to the court. So I had to breeze through it.
It should not turn counterproductive to you.
ಆ ಕಡೆ ಹೋಗುವಾಗ
ಅದಕ್ಕೆ when you come this side, they should not turn
One
counterproductive.
But my lords, because
191B.
these are aspects of law, my lords, we had to place whatever is there, my lords.
Correct.
Whether
No, no,
it
but
works to our
The
benefit or
lighter
not.
weight, can't help. Yes, ಮಾರ್ಕ್ ಅಂದ್ರೆ ಅದಲ್ಲ, ಪ್ಯಾರಾಗ್ರಾಫ್ ನಂಬರ್ ಹಾಕೊಡಿ ಸಾರ್. ನೀವು ಪೇಂಟ್ ಮಾಡ್ಕೊಡ್ಬೇಡಿ.
ಆಮೇಲೆ ನನ್ನ ಅವ್ರದ್ರಲ್ಲೂ ಮಾರ್ಕ್ ಮಾಡಿದ್ದೀನಿ ನಾನು ಅವ್ರದ್ದು ಮಾಡಿ.
I want only the paragraph numbers.
Yes.
Sir, I for one,
Yes, Minister. Could I
is
give
always
my-
the firm opinion that any order, whether it is 156(3) or 204, or cognizance being taken at 191B, 190B,
191A.
191A or B, only two.
Yes,
See, taking of cognizance ಅಷ್ಟೇ, issuance of process and 204.
not four, correct.
So,
Correct.
ಇದರಲ್ಲಿ, if it does not bear any application of mind, it definitely
And
causes.
it's what
a
happened
problem.
in Pradeep Vader was exactly this. They said when an investigation
No
has come.
problem. Post Pradeep Poder, there are many.
No, all those. I've produced even post Pradeep Vader. My lords,
Post Pradeep Poder ಯಾವ್ದು ಇಲ್ಲ ನಿಮ್ದು.
how do?
ಇದೇ ಇದು ವಿಕಾಸ
No.
ಇರೋದು.
My lords,
ವಿಕಾಸ
ತಮ್ಮದೇ
ಶಫಿ
judgment
ಅಹಮದ್.
ಇದೆ.
ಅದು ನಂದಲ್ಲ, ಸುಪ್ರೀಂ ಕೋರ್ಟ್.
ವಿಕಾಸ
ನಂದಿದೆ, but
ಶಫಿ
ಸುಪ್ರೀಂ
ಅಹಮದ್
ಕೋರ್ಟ್
ಇವೆರಡೇ
ಇದೆಯಲ್ಲ.
ಇರೋದು.
No, no.
Post
Supreme-
Pradeep Poder,
My
you
lords-
give me, post Pradeep Poder, you give me one judgment of the apex court which follows Pradeep Poder and says reason should not be there.
Reasons?
Should
My
not be.
lords, no,
Reasons.
Pradeep Vader also doesn't say that. My lords, Pradeep Vader says,
Pradeep Poder says at 108.8 that when the cognizance is taken on a police report, that is the charge sheet filed, it need not bear reasons like how cognizance is
elaborate
taken
reasons. Yes, my lords.
on a
That's-
private complaint.
Absolute.
All
Absolute.
right?
Absolute.
Yes.
Now, if it's a private complaint, my lords, they may have to say, what is the gist of the allegation? Because there's no investigation done.
True.
Why you are satisfied that the gist
That-
constitutes the offense?
That does not mean that the duty of the concerned court to record at least some semblance of application of mind is obviated.
My lords, I leave it to the court, my lords. This is what I find
Yes,
so far
sir.
as police reports are
we'll-
concerned.
we'll
Because,
cut-
my lords, I may also say this, I'm sure Leonard Senior will also agree. More than 80%, my lords, more than 80% of all the cognizance orders on police
Are like
reports.
this, correct? Should there not be a correction?
My lords. the
You tell
prob-
me, should there not be a correction?
My lords may have to. lay
We
it
also
down.
follow what is happening throughout and say, yes, this is all right. That is why apex court has later on written, there should be a correction.
My lords, I leave it to my lords to, if it's going to be, at least then, my lords may at least point out what is expected to be there, my lords, at least to that extent.
What
Do they-
Supreme Court has said, we will.
They
see.
don't say, my lords, what is expected to be there to
ಈಗ
show
ವಿಕಾಸ್ ಚಂದ್ರ ಅಲ್ಲಿ ಏನಿದೆ ಹೇಳಿ.
My lords, Vikas Chandra Ali,
We'll hear
my
the
lords,
senior
Vikas Chandra Ali, 306 B report. B report
Yes.
ಆದ ನಂತರ
Yes.
202 inquiry. Inquiry ಆದ ನಂತರ there was cognizance taken without application of mind. That is Vikas Chandra. That's the last of the judgments, 2024. And my lords, in all the judgments, we find Pradeep Vader.
That's the problem.
We find Pradeep
Yes.
Vader. So kindly notice even Vikas Chandra, why it was done, my lords. It was a case of a virtually a B report, 202 inquiry and then process being issued.
Assist the court, my lords. I'm led by senior. but
senior.
officers-
Sir.
Please.
Sir, yes.
Lord, may I just request your lordship to kindly turn to paragraph 13 in Vikas.
1-3.
1-3 minute. A close scrutiny of the position of law. My lord, whatever the judgments which Malaran Fund has been referring to or has referred to, my lord, are referred to in this judgment by the Supreme Court, including Bhushan Kumar. Your lordship would get at item
Yes.
number 6 of the judgments. All the judgments have been referred to.
Yes.
Bhushan Kumar, Bhattacharji, Ramesh Kumar, Nitin Datta, almost all the judgments. A
Yes.
close scrutiny of the position of law revealed from the aforesaid decisions, which are constantly and consistently being followed by this court, would reveal that issuance of summons is a serious matter and therefore shall not be done mechanically, and it shall be done only upon satisfaction of the ground for proceeding further in the matter against a person concerned based on the materials collected during the inquiry. In the aforesaid circumstances, the next question to be considered is whether a summons issued by a magistrate can be interfered with in the exercise of the power under section 482. In the decisions of Bhushan Kumar and another NCT Delhi, and in another judgment, etc., my lord, and Pepsi Foods Limited, etc., this court held that a petition filed under section 482 CRPC for quashing an order summoning the accused is maintainable. There can't be any doubt that once it is held that sine qua non for exercise of the power to issue summons is the subjective satisfaction of the ground for proceeding further, while exercising the power to consider the legality of a summons issued by a magistrate, certainly it is the duty of the court to look into the question as to whether the learned magistrate had applied his mind to form an opinion as to the existence of sufficient ground for proceeding further, and in that regard, to issue summons to face the trial for the offense concerned. Well, this would be important. In this context, we think it appropriate to state that one should understand that taking cognizance empowered under section 190 CRPC and issuing process empowered under section 204 CRPC are different and distinct. See the decision in Sunil Bharati Mittal versus CBI. Well, what needs to be seen is, But application of judicial mind at two stages. The first stage is under section 190. It may be under 191A or 191B or 191C. That is for the limited purpose of taking cognizance. I am sure your lordship would certainly agree with me. I would say, my lord, emphatically, that there is little application of mind for the limited purpose of taking cognizance of the offence in exercise of the powers closed upon the magistrate under 191B. It is there. But subsequent thereto, as the Supreme Court has said, taking of cognizance is something totally different from issuance of process under section 204. Whether it is a private complaint or a police report, but the court gets the jurisdiction to order issuance of process only under section 204 and not by invoking any other provision under CRPC. But here, there has been absolutely no application, no order as such under section 204, other than saying issue summons.
Yes, we will set right the 80% now.
But even in Shafi Ahmed, well, this is also a state case.
All
Yes.
this is considered. Even if you see this judgment in Sharif Ahmed.
Yes, Mala, Sharif
Hasan
Ahmed.
Bhatta is
All this-
considered.
Even because is also
Pradeep Wadir
referred
is
to.
considered.
Sunil
My
Bharti is
lords,
referred
I'll
to.
just point out.
Para
My lords,
17.
Sharif, my lords is seeing Sharif Ahmed.
Yes.
Please
sir.
notice Sharif Ahmed,
Yes.
the
sir.
starting point itself at page
Yes, sir.
48. Page
49
48.
judgments have been referred to.
49 ಅಲ್ಲಿ, paragraph 2 ಅಲ್ಲಿ, please notice what the court considered at line 5, my lords. They have done the judgment in two parts, page 49 ali, my lords.
No problem, sir.
My lords, kindly
We will
notice.
hold that reasons are
Allah.
required.
First part relates to the legal issue, that is the content of the charge sheet. My lords,
No, all of them are on police reports.
yes,
Yes.
my lords,
There are police
which I
reports.
have given, my lords.
Hello, sir has given.
No.
Ah.
There's-
No,
my
it
lords,
is a police report.
I'm sorry, my lords. The
Shafi
very
Ahmed
first,
is the
my
latest
lords,
one.
they're relying on,
Vikas Chandra is on private complaint.
Sachin Garg is on a private complaint.
Huh.
My lord, Sharif Ahmed, paragraph 2 may be noticed what it was about. Vikas Chandra was a case where it was a B report, 202 inquiry and issuance of process. These are the three judgments.
I will hold reasons are necessary.
Anyway, my
Yes.
lords,
Sunil
it is-
Bharti
it is
Mittal,
my lords,
my lord,
So
Sunil
that
Bharti
things
Mittal.
get clear.
yes, my lords, if that is the case, my lords, probably if my lords hold so, some kind of guidance, my lords.
And definitely I will.
Some kind of guidance. What do we
Definitely I
mean
will.
by
Like
application
how I
of
did in
mind?
Ashok's case. I will
ಏನಾದ್ರೂ
do
ಒಂದು
it,
ಸ್ವಲ್ಪ
yes.
my lords. Otherwise, my lords, there at loss, my lords. When a police report comes, application of mind andre, are we supposed to say CWs 1 to CW so are there in the charge sheet? This many documents are there. I am prima facie satisfied. Are they expected to say that or what? My lords, some guidelines will really help in the matter, I feel.
Definitely, yes. Otherwise it keeps coming here and going back.
Again, and at what stage, my lords? Sometimes if trial begins,
ಇಲ್ಲ ಇದ್ರಲ್ಲಿ ಏನಾಗಿಲ್ಲ.
ಅಲ್ಲ, trial ಆಗಿದ್ರೆ, when
Once
trial
issue
begins and they say cognizance order is bad for this reason, we have to set
That-
it back.
Putting the clock back may be difficult. That is why.
Because that's why, my lord,
Yes.
this order may have some consequences in all the cognizance orders, my lords. That's the
Yes.
reason whatever is the law on the point, we have placed it.
No problem. That's.
Yes,
Assistant-
deeply
But
obliged.
Assistant is never
Did
found.
not refer to that Sunil Bharti Mittal, my lord. There is a case of
Please
CBI.
admit. Yes.
Sunil Bharti Mittal's case.
Para
eh,
53
my
of
lords,
that.
Sunil Bharti Mittal's case, ali, charge sheet was filed against the companies. Issuance of process was against the managing directors. That they found fault with. Doctrine
while
of
Sunil-
alter ego.
while-
No,
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 while
it is not the
saying-
facts. It is not the facts.
If-
It is the law that
if-
came to be laid down by the
No,
Supreme
if-
Court.
If you see Sunil Bharti Mittal, go to para 51
Last
to
paragraph,
53.
50.
My lords,
So company was not made a party true and it was, but Supreme Court
company
says
was made a party.
directors ಮೇಲೆ ಕೊಟ್ಟೆ ಮಾಡಿದ್ರು.
directors ಮೇಲೆ issuance of
Now,
summons.
Supreme
Eh?
Court says 204, what is the requirement
Yes.
of 204 is said in that.
My lords, that again they said application of mind was lacking because you're taking cognizance against a person who's not an accused.
It's all right.
And that's
But
where doctrine
sir-
of alter ego came there.
First thing is application of mind and giving reasons for a judicial order. You need not, it cannot be fact based. It pervades every fact. It should contain reason. That's all.
Anyway, my lords.
If it is on case to case basis, you have to give reasons, then it becomes dangerous. It should pervade every fact. Reason should be there.
My lords,
We'll send it back.
Pepsi Food again was a private complaint.
That's all
Sunil
right.
Bharti
Pep-
Mittal
No, no,
Sunil
what is the
Bharti-
law laid down has been referred to. That's
See,
all.
that is why I said, we can't distinguish it by facts. This is this,
No,
this
the
is
law-
that. Reason should
Well-
be there, reason should be there, that's all. Yes,
So, my
Well,
lords,
Pepsi and other
we are
judgments
at
are
my
referred
lord's
to
hands
because of
on
the
this
law that
matter,
is
the
laid down in those
guidelines to be laid
cases.
down.
definitely, sir, definitely. Yes, allowed remanded back. I'll lay down, right, ಈಗ ಬರೆಯಕ್ time ಇಲ್ಲ. Take ಮಾಡಕ್ time ಇಲ್ಲ. That's the only ground.
Yes.
And time limit I will fix
Time,
to.
my lords, time limit is most
Time
important.
limit I will fix to redo the
Because
entire
this was a
exercise.
matter, my lords, during the crime stage, my
Correct.
lords had
Not even,
rejected
summons is
before
not
it.
even issued. Where is the question of fixing time limit, sir?
No,
Allah,
I
in the
will
order
fix
to
the
pass
time
my
limit to redo the process, sir.
Please, please,
Yes,
please.
not for conclusion.
My lord,
Trial
if that
conclusion
were to be
Allah.
said, even in the second round of litigation, my lord, if the trial magistrate were to take cognizance, it is always open to me to approach your lordship and
No, that's all right.
invoke my lord's jurisdiction.
I am asking the magistrate to finish his process within a time limit, that's all.
Please, my lords.
Your lordship may
Redoing the
kindly say,
exercise.
your lordship
Redoing
may
the
kindly
exercise.
say, the other contentions are left open.
All other contentions left open
That's it.
of both the parties.
Your lordship may recall to your lordship's memory
Sir.
that the report of the handwriting expert or the opinion of the handwriting expert is in my favor.
No,
That
I
is
the
beg
whatever.
to
No,
differ.
I am not entering into all
My
that,
lords,
sir.
I beg to differ on
Please,
that.
I am not entering into all that.
Differ on that. They say it is not the signature of my.
And I am not entering into all that at all. Except the order of cognizance, only to issue some guidelines, we'll do that.
Please, deeply obliged.
Right.
That's,
My name has been misspelled in the cause list. Akash Kumar Gowda ಅಂತ ಆಗಿದೆ.
FSL ಕಳ್ಸೋಣ.
ಇಲ್ಲ.
Yes.
It's a small correction.
Right.
Akash Rao ಅಂತ.
So and so, register to appropriately print the name of so and so. Next.
Issue, my lord.
Well,
That's your-
one aspect which even they wanted to point out, while taking cognizance and application of mind, it should not be of such a nature that it goes to the next step of framing of charge. It should not be of
I
that
know
step.
what-
That's what they were also a little concerned about.
All right. I know what,
Well, otherwise we lose
I am very well aware of that.
HPC whole process will go, man.
It shouldn't, it shouldn't
Go to that
preclose it.
extreme
No,
also.
There should be some application of point, that's all. Very, I have seen so and so.
Guidelines will wait for. Obliged.
Yes, next.
Lords, I appear the petitioner, Lords, the matter wherein the cognizance is taken for section 11 of the Aircraft Act
I know, yes.
without.
One issue that I think there is he's relying on since the departmental inquiry is exonerated there.
No. Section 11
Lords,
straight away, departmental inquiry
Lordship,
today.
Point itself, Lords, may.
Your lordship may see page 59.
59.
59, my lord. Number 8.
Hmm.
The
Yes.
The last point, my lord.
Aircraft had
Aircraft-
one passenger.
Yes.
Ah.
And so on so. Though the onboard on aircell work flight shall require an approval of DGCA.
Aircraft Act ಕೊಡಿ madam.
Though the
Madam. Aircraft Act ಕೊಡಿ. Yes.
You can pass this.
That's it. Section 11.
Flying has to cause danger.
1 minute. Sir. Section 11. Penalty for flying so as to cause danger. Is it defined? What would cause danger is defined somewhere?
No. Lords, even otherwise, Lords, 12B is on the point insofar as this very action could not have been the initiation of the
Rule 12B.
12B, Lords, section 12B. Without prior permission from the DGCA.
Where is this section 12B here?
12B, ma'am, my lords, it was amended in much later on.
Please give it. ಇದು ಬೇರೆ ತರಿಸಿ ಅಮೆಂಡ್ಮೆಂಟ್ ಆಗಿಲ್ಲ.
Lords, that would clearly say that.
Cognizance of offense.
Please, Lords.
Punishment made by previous sanction in writing. ಇದೊಂದೇ ಸಾಕಲ್ಲ ಇನ್ನೇನು
ಅದರಲ್ಲಿ
sanction ಇದೆಯಾ?
page 19, my lord, last
DGCA sanction ಇದೆಯಾ?
page 19, my lord, last pair.
What they do, my lord, they do some correspondence with DGCA.
Page
19, my lord, last para. The preliminary report was sent.
What report was sent?
The preliminary report. Was sent.
Accident aita.
Yes, ma'am.
What happened in the accident?
The aircraft toppled close to stopping.
All right.
Nobody got hurt. It was due to birds and stray animals.
My lords, in the report, it would very clearly
Last
say
para,
that there is.
that necessary approval is obtained to conduct investigation.
Preliminary report is sent to you. Therefore, you are requested to lodge FIR
According to section.
according to
Aircraft
section
Act,
11 and carry out necessary investigation. Who has given?
Complaint.
Jagdish,
Yes.
come to 12B. No court shall take cognizance of any offence under this act.
Correct. ma'am.
All
It's a
right.
cognizant.
Complaint with previous sanction in writing by DGCA or DGBCA. These are not your authorities.
No,
It is
they're not
Government
our-
of India.
Yes.
Whose sanction have you taken now?
The complainant says, my lord, that the approval is under section 1711. Was
Where?
obtained.
12B compliance ಎಲ್ಲಿದೆ? Where is the document?
At 12B compliance is not there, but
Goes,
That's all.
it straight away goes. The petitioner is before this court. Obrella.
Please.
The petitioner is before this court calling in question proceedings in CC 15835 of 2023 registered for offence punishable under section 11 of the Aircraft Act 1934, hereinafter referred to as the Act for short. The said proceeding arose out of registration of a crime in crime number 95 of 2022. The petitioner is a pilot.
Please.
A complaint comes to be registered on 19/4/2022 by the first respondent police, alleging that the petitioner, a pilot, was flying aircraft VT, page 5 al mark madideni, so and so. It is said to have veered to the left side and got toppled on account of bird antellide illi.
Bird activity.
Got toppled with no injuries to anybody. And the same was termed to be an aircraft accident due to the negligence of the pilot. And a crime then comes to be registered in crime number 95 of 2022 on 19/4/2022. Investigation commences on the registration of the crime. The police is said to have investigated into the matter and filed a charge sheet before the concerned court. The concerned court takes cognizance of the offence under section 11 of the Act in terms of, where is the order taking cognizance?
Page 26.
In terms of the order dated. Order date. End data by the. On 5/7/2023, taking of cognizance against the petitioner and registration of the crime or issuance of summons has driven the petitioner to this court in the subject petition. Heard so and so. The learned counsel appearing for the petitioner would quote a threshold bar of the concerned court taking cognizance of the offence, placing reliance upon section 12B of the Act. The learned counsel would submit that the court could not take cognizance of the offence unless there is sanction to prosecute the petitioner from the hands of the DG's Director General Fullhaki, DGCA, or the authorities enumerated therein. It is an admitted fact enumerated therein. The learned counsel for the learned additional SPP would take this court through a communication or complaint.
Complaint.
Take this court through the complaint to demonstrate that there has been permission to lodge the FIR by whom? Permission to lodge the FIR, terming it to be an aircraft accident. And he would submit that since the court has now taken cognizance, the proceedings should not be permitted to be, the proceedings should not be interdicted, and it is for the petitioner to come out clean in a full-blown trial. Given my so and so. The four narrated facts are not in dispute. An event, an accident rather, happens on Jakkur Aerodrome on 19/4/2022. The aircraft topples on the aircraft topples of being hit by a bird, is it?
My lord, it doesn't get hit. He avoids birds and dogs
so
the runway.
the aircraft is veered to the left to avoid birds and dogs on the drome, and which topples the aircraft. This toppling of the aircraft is said to be a crime or depicted to be an aircraft accident, and a complaint is drawn by the first respondent. The complaint dated 19/4/2022 reads as follows. The last paragraph of the complaint is indicative of the fact that a kind of permission is taken to register the crime. Police investigate into the matter. The concerned court takes cognizance of the offense. The order taking cognizance reads as follows. The issue now would be whether the concerned court could have taken cognizance of the offense contrary to the act. It becomes germane to notice section 12B. Section 12B reads as follows. Subsection 2 of section 12B mandates, section 12B, subsection 1 of section 12B mandates that no court would take cognizance of the offense unless there is a previous sanction in writing by either the Director General of Civil Aviation, Director General of Bureau of Civil Aviation, or Director General of Aircraft Accidents Investigation Bureau, as the case may be. It is an admitted fact in the case at hand that there is no sanction by any of the authorities enumerated in section 12B. In that light, the very act of taking of cognizance by the concerned court would tumble down, leading to the petition.
Section 12B says complaint. That's also we filed a charge sheet.
No court shall take cognizance of any offense on a complaint. Investigating ಮಾಡಿದೆ ಅದು ಆಗಲ್ಲ.
Permission
It should have been a private complaint.
Non-cognizable offense. 17th, the complaint is given. 18th, an NCR has been issued. The same verbatim complaint on 19th.
1 minute. So and so. It is an admitted fact that there is no sanction, sanction of prosecution of the petitioner, even on a complaint. It becomes germane to notice that a complaint was registered on 17/4/2023, which was rendered with a non-cognizable report on the same day,
Yes.
on 18/4/2023. And on the very next day, the verbatim complaint is registered before the jurisdictional police. The complaint itself was not maintainable. Therefore, on the aforesaid grounds which would touch upon the jurisdiction, the petition deserves to succeed. Allowed quashed.
That's the date while dictating of the incident is on 17/4, not 19.
Complaint is 19/4.
Complaint is 19/4. Incident is on the aircraft. Incident is on 17th.
17/4.
Please.
Where have you said 17/4?
Synopsis, page number 1.
No, para 5 alide. Same aircraft was filed on 17/4. All right, so corrections that will do it. Yes.
But on a lighter note, there was a discussion on application of mine. Here is a pilot who lands the plane. Jakur Aerodrome is known for dogs, birds, and all that. And that, and just to prevent that liability, he goes and lodges.
Yes.
The pilot is creating danger to himself. With the other
Yes.
Oblige.
Yes. 18.
Lord, I appear for the complaint is lodged against the petitioner. My lord, is a storing of the petrol and diesel in the
ಮೈಕ್ ಹತ್ರ ಬನ್ನಿ ಸರ್, ಇಲ್ಲ ಮೈಕ್ ತಗೊಳ್ಳಿ ನಿಮ್ಮ ಹತ್ರ. ನೀವು ಸ್ವಲ್ಪ ಜೋರಾಗಿ ಹೇಳಿ.
My lord, the complaint is lodged by the food inspector against the petitioner. My lord. There is a storing of the petrol and diesels in the 4 cans. My lord. It is the theft.
Oh, this is 307 and 379.
379, 406, 420.
Yes, sir. You file your objections.
Will file. The charge sheet has been filed. Charge sheet is filed. For offense under 406 and 420. The petrol.
379 ಇಲ್ವಾ?
379 ಇದೆ.
ಚಾರ್ಜ್ ಶೀಟ್ ಅಲ್ಲಿ ಇದೆಯಲ್ಲ 379 ಇದೆ.
379, 406 and 420.
EC ಇಲ್ಲ.
EC ನೂ ಇದೆ.
Right, come. List the matter on 22nd. Objections, if any, by the state. Next.
petitioners of a teachers in a school. Respondent was a parent. In the year 2014, a complaint and counter complaint was filed. Charge sheet was also filed. This honorable court in criminal petition number 4302 and 3147, page 95, madam. Page 95, para 6. Quashed the both the complaints on merit.
Page?
Page 95, para 6. madam.
$95.
Yes, ma'am.
Para
Para 6.
page 95.
Serial number 19. madam.
Ah,
Para 6. Shall I read, my lord?
93. 92.
93 is the order. Ink page 95, para 6.
Quashed proceedings in his favor.
So both case and counter case were quashed.
All right.
Based on the same fact, after lapse of 10 years, this
10
fresh,
years, sir.
after 10 years,
Ah,
a fresh FIR has been filed. Court has, without referring to the High
same,
Court,
same set of facts.
same set of facts.
Page.
Allegation is that I am
Pa- Page. Where is the complaint?
the complaint,
Page 22.
page 22. Page 22, FIR is at page 17. ಕೃತ್ಯ ನಡೆದ ದಿನ 1/4/2013 2014. ವರ್ತಮಾನ ಸ್ವೀಕರಿಸಿದ ದಿನಾಂಕ 6/7/24.
ಒಂದು ನಿಮಿಷ. ಇದ್ರದ್ದು FIR ಎಲ್ಲಿದೆ? ವಾಶ್ ಆಗಿದ್ದ FIR ಎಲ್ಲಿದೆ?
Page number 72.
Page 72. Page 72 and 83. ಅದು ಕೃತ್ಯ ನಡೆದ ದಿನ 1/4/2014, ದೂರು 10/4/2014. Counter case is at 82, man.
Heard the learned senior counsel Divakar appearing for the petitioner. The complainant and these petitioners had preferred criminal petition 4302 of 2017 and criminal petition 3147 of 2017. The contents of the crime was for offense punishable and the allegations in the complaint registered by the present complainant was for offense punishable under section 341, 506, 509, 354. And in the complaint registered by the petitioners against the complainant was for 506, 504 and 506, both of which come to be quashed by a coordinate bench of this court in terms of the following order. After the said order is passed on 1st February 2023, long thereafter, based upon the same set of facts and the same incident, as both the crimes would indicate that the period of crime was either from 1/4/2013 to 10/4/24 or 10/4/2014 or 10/4/2014 as the case would be. The complaint is again registered. Prima facie, it depicts abuse of the process of the law on the part of the petitioner, on the part of the present complainant. Therefore, there shall be an interim order of stay of further proceedings these petitioners till the next date of hearing.
Connected matter is serial number 50.
Barley.
60.
Yes. Next.
Same set of facts.
Aಯ್ತು ಬರ್ಲಿ serial number ಬರ್ಲಿ. Next.
My lord, my colleague will have to go to house.
ಸಾಕು ತೊಂದ್ರೆ ಇಲ್ಲ. List after 4 weeks, interim order subsisting shall continue to the next date of hearing.
21.
Appearing for the petitioner, my lord. Your lordship had earlier disposed of the matter against the juvenile accused,
Yes.
and the judgment in page.
Now what
number-
has happened?
Now the other non-juvenile accused, my lord.
Oh, the same.
Same against then the
Covered
allegation.
is Annexure C, page 27. Disposed.
Disposed.
Disposed, my lord.
No, pardon, I didn't hear you.
Yes.
Oh, sorry. Dreadful.
Yes.
22.
Appear for the petition in this one. Offense under section 420, my lords. Complaint is at page number 16, my lords. This is a case wherein, my lords, criminal law is set into motion only for recovery of money, my lords. Page number 16, my lords, is the complaint. My lords, may I read, my lords?
1 minute. It's all right, but how much money you have to pay?
My lords, totally, my lords, premium was paid for 22 lakhs, my lords.
Mm.
Over a course of 6 months, about 12 lakhs, all the claims were cleared, my lords. From October to April, my lords, all the claims were cleared. And I have also submitted a document to demonstrate all the claims. April, my lords, we ran into some financial trouble, so about 7 claims were not cleared, my lords.
So when do you clear?
My lords, we will do the needful, my lords. The only aspect is, my lords, in their prayer itself, they are saying, my lords,
It's all right. When do you clear?
we are in the process, my lords. We will ensure that, my lords, my only submission.
Clear ಮಾಡಲ್ಲ ನೀವು.
Allah, my lords, is 420 attracted
It's
in this?
all right, that I'll answer.
Please. Allah, that it, my lords, they have other remedies, my lords, wherein they can approach civil court, they can approach NCLTs, my lord. My only submission is, my lords, 420 is not attracted in this, my lords.
Pain is 5 lakhs, 5 lakh 54.
ವಾಪಸ್ ಕೊಡಿ.
Allah, my lords, that it is a.
Anyway, limited stay will grant till his appearance.
Please.
Petitioner is before this court calling in question registration of a crime in crime number 80 of 2024 registered for offense punishable under section 420 read with 34 of the IPC. The complaint registered by the second respondent complainant and its purpose is gathered in paragraph 5 of the complaint, which reads as follows, page 18. It is undoubtedly registered for recovery of money or dues that the complainant is, where the petitioners are allegedly due to the hands of the complainant, permitting offense, permitting the investigation into the subject crime would run foul of the judgment of the apex court in the case of Lalit Chaturvedi versus so and so 2024 SSC online SC page 179. Therefore, there shall be an interim order of stay 171 interim order of stay of further proceeding, further investigation, query the petitioner till the next date of hearing. Yes.
23.
1 HCGP to emergent notice.
23 we have not.
Freezing of bank account, my lord, by ED authority.
My lords, file my objections in this matter.
ಯಾವಾಗಿಂದ ಫ್ರೀಸ್ ಆಗಿದೆ ಸರ್?
My lord, since 21, your lordship.
ವೈ ಇಲ್ಲಿವರೆಗೆ ಯಾಕೆ?
My lord, we approached the special court. Special court has rejected it. Lord, thereafter, my lord, we have filed this petition. My lord,
Why is it frozen?
My lord, frozen, my lord, because they registered ECIR, my lord. And thereafter, my lord, predicate offense is quashed.
Prior to my lords,
My lord, we have produced the copy, my lord, that.
Predicate offense ಇದೆಯಾ ಇಲ್ವಾ?
Lords, there are 3 cases, my lords, not 1. There are 3 cases.
No, not connected
Sorry,
to
my lord.
that. Those are all subsequent
It is a
post
cricket betting.
court
No.
seizure.
One clarification.
Please, your lord.
Which predicate offense led to closure freezing of the account?
My lord, this is crime number 177, my lord.
177.
177
Pursuant to
bar-
177, the accounts were frozen?
Yes, yes. ma'am. Pursuant to ECR registered by ED, my lord. Yes, yes.
So
Predicate offense is this.
The drill goes this way.
Yes.
Now predicate offense is 177.
177, my lord, that
Ah,
has been quashed
all-
by this court.
No, 1 minute, sir. After that, ECIR.
ECIR, my lord.
After the ECIR, the freezing takes place. Correct?
Freezing takes place after quashing of the predicate offense, your lordship. Still
But
what's the
ECIR
case?
is still there.
ECR also registered, my lord, subsequent to quashing of the proceeding.
Subsequent to quashing.
Yes, yes, my lord, that is
Then,
what
lords,
it
if
is.
there is
They
an
cannot
agreement to
do
take
that.
instructions, my lord.
Yes,
I
sir.
have entered my lord's appearance day before yesterday.
Ah.
Take instructions, please.
What instructions, sir?
Lords, At least IO in at least instructions.
Huh?
I'll file my objections in this, my lords.
List on Monday in the fresh matters list.
2020 itself predicate offense has been quashed.
cases,
ECR
what
is
I can-
registered subsequently.
ಇಲ್ಲ ಅವರ ಒಂದು ಲೇಟೆಸ್ಟ್ ಜಡ್ಮೆಂಟ್ ಇದೆ ಮಡ್ರಾಸ್ ಹೈಕೋರ್ಟ್ ಡಿವಿಷನ್ ಬೆಂಚ್ ದೇ ವಿಲ್ ಗೆಟ್ ದಿ ಅಂಬಲಿಕಲ್ ಕಾರ್ಡ್ ಡಸ್ ನಾಟ್ ಗೆಟ್ ಕಟ್ ಬಿಕಾಸ್
Well,
ಆಫ್
that is there, but my lord,
ದೇ ವಿಲ್ ಗೆಟ್ ದಟ್ ಆನ್
here, not only that, your lordship, non-compliance of section 17, my lord, 1A and 4.
reporting
Not
it to
reported, not sought for retention. My lord,
Take
that
all these
itself is a
instructions.
ground, my lord, for,
both will see will answer
Please,
Monday. Yes.
please.
and this is covered by decision of Supreme Court, my lord, not complying section 17, my lord.
See, my lords, what is the situation? Because
No situation ಏನಿಲ್ಲ
ಏನಂದ್ರೆ
ಅಷ್ಟೇ
because my lords, ಮೊನ್ನೆ ಕೊಟ್ಟಿದ್ದಾರೆ.
ಡಿವಿಷನ್ ಬೆಂಚ್ ಜಡ್ಮೆಂಟ್ ತಗೊಂಬನ್ನಿ ಮಡ್ರಾಸ್ ಗೊತ್ತಿಲ್ಲ ಅಂದ್ರೆ ನಿಮಗೆ ಮಧುಕರ್ ದೇಶಪಾಂಡೆ ಕೇಳಿ ಕೊಡ್ತಾರೆ.
That's a predicate offense in that case was quashed in this court, my lords. We were early.
Yes, sir. No problem. Yes. ಇದರಲ್ಲಿ ಕ್ವಾಶ್ ಆಗಿದೆಯಲ್ಲ
Like in a year.
ಆಯ್ತು ಮಂಡೇ
Please.
24. Petitioner before your lords, formerly the deputy director of the Prudent Civil Supplies Fund, is now arraigned as accused number 1, calling in question FIR registered against her for offense under 7A of the Prevention of Corruption Act.
serve on BB Patil. Counsel to BB Patil is directed to accept notice for the respondent Lokayukta. List this matter on first along with connected matters. ಇವತ್ತೇ ಸರ್ವ್ ಮಾಡಿ. Yes, yes. Abhinay?
8-2, my lord.
Huh?
8-2, POCSO. A1 is acquitted now.
A2, ಅಲ್ಲ R2.
ಅವ್ರು 8
ಅಲ್ಲ sir, respondent
ನೀವು 6
complaint.
ಗೊತ್ತಾಯ್ತು. ಏನಿದೆ A1 ಅಕ್ವಿಟ್ ಆಗೋಗಿದೆಯಲ್ಲ
ಹೌದು ಸ್ವಾಮಿ.
ಅಕ್ವಿಟಲ್ ಆರ್ಡರ್
ಆಗಿದ್ದಾರೆ.
Page 111, my lord.
ಮ್ಯಾರೇಜು ಆಗಿದೆ
Marriage ಆಗಿದೆ.
ಈಗ ಯಾಕೆ ತೊಂದರೆ ಕೊಡೋದು?
ಆಯ್ತು.
Yes. The petitioner is before this court calling in question proceedings in special CC 891 of 2018 registered for following offences. The petitioner, mother ನೀವು? The petition,
ಹೌದು.
sister. The petitioner is the sister of accused number 1. Why you are not available for trial?
Split charge sheet.
The petitioner at the relevant point in time was not available for trial. Therefore, the accused number 1 was tried. The accused number 1, ಇದು ಮನೆ ಡಿಟೇಟ್ ಮಾಡದ್ನ ಇಲ್ಲಿ ಯಾರು ಕೊಟ್ಟೆ?
320 application ಬೇಡ ಮೇನ್ ಆರ್ಡರ್ ಮೇಲೆ ಮಾಡಿ.
Oh, settlement ಬೇಡ. Yes. The petitioner was tried. Accused number 1 was tried and the trial in special CC 202 of 2017 ends in an acquittal. The said acquittal has become final and it transpires that the victim has also married someone else.
A1.
ಅವ್ರನ್ನೇನಾ?
ಹೌದು.
Oh, married A1 and they are now living together. The petitioner is the sister of accused number 1. On account of her non-availability for trial at the relevant point in time, a split charge sheet is drawn in special CC 891 of 2018. And the trial is now sought to be continued against the petitioner, accused number 2. It is therefore he is before this court seeking quashment of the entire proceedings. The learned counsel appearing for the petitioner submits that the accused number 1 against whom all the offences under the POCSO Act has been acquitted and the accused number 2 would undoubtedly get acquitted even if trial is permitted. The learned counsel appearing for the state would though refute the submission, contending that the petitioner also should come out clean in a full-blown trial. As is the case of accused number 1, she would seek dismissal of the petition. I have given my swords order the acquittal.
Page 111.
The aforenarrated facts are not in dispute. It becomes germane to notice the order of acquittal of the accused number 1.
Evening, my lord, page 110, para 90.
The reasons so rendered by the concerned court is as follows. As it happens every time, the victim has not supported the case of the prosecution and the as by then the victim girl had married accused number 1. If victim girl has not supported the case against accused number 1, it can be hardly said that she would support the case against the accused number 2, the sister of accused number 1, permitting further trial in the case at hand only to get, only for the petitioner to get acquitted at the end would become an abuse of the process of the law, and a waste of precious judicial time, the view of mine. So, yes, next.
26.
Lords, may please see the office note part 2, my lords. It's maybe tagged along with criminal petition 8213 of 2024, my lord.
8213, yeah.
Yes, my lords.
Yenadu?
No, this is, in that case, it was for release of money, my lords.
All right, tag the petition along with so and so. List
So there's
after
an
vacation.
interim order in that case, my lords. Status quo.
ಅದು ಬಂದಿಲ್ಲ ತಾನೇ ಇವತ್ತು?
That has not come today, my lord.
ಬಂದಿಲ್ಲದೆ ಇರೋ ಕೇಸಲ್ಲಿ ಇಂಟ್ರಿ ಮಾಡಿ ಎಕ್ಸ್ಟೆಂಡ್ ಮಾಡಲಾ?
No, I mean, that same may be extended here. So.
We'll see, yes. ಅದು same, similar set of facts?
Yes, my lords.
So, land council companion petitions, yes. Now, entry order ಕೊಡಿ, copy.
Your discharge application is still in criminal revision.
Rejected.
Status quo.
So, same tag, yes, next.
27.
To appear for petitioners, my lord. My lord, a crime is registered under section 417 and 420 of IPC for non-payment of EMI, my lord, through the NBFC, my lord.
In the meantime, yes, next.
Grateful, my lord.
28.
Final
Here
hearing.
for respondent number
Final
3.
hearing.
Final hearing. What final hearing ivattu?
Because it was.
The list on 21st interim order subsisting shall continue to the next.
Lord, there is one more petition which
Kodi.
emerges from the same
Number ಕೊಡಿ.
1230 of 24, my lord. That may be tagged
12:30 time, sir, yes, ನೋಡಿ. ಇದು number ಬರ್ಕೊಡಿ ಮೇಡಮ್.
WP, that is criminal petition, madam.
ತೊಂದ್ರೆ ಇಲ್ಲ ಕೊಡಿ. Yes, next.
29.
ಇದು will hear it after vacation. ಈ
My
time
lord,
ಅಲ್ಲಿ.
date may be fixed.
This has to 21st ಹೇಳಿದ್ನಲ್ಲ ಮೇಡಮ್. ಇದು
In
ಅಷ್ಟೇ.
fact, virtually your lordships have heard the matter. The allegation is only so far as the identity card. Through tender, my lord, the election kit has been given to us. How can it be an offense?
So if it is so simple as
Not so, it's not so.
is what he is saying.
No, under the scheme, election kit which contains the photograph of these people.
It's not same.
Representative.
We'll hear it immediately after vacation. Heard the learned senior counsel B. Lakshmi
Lordship may say further hearing ಅಂತ. ತಿರುಗಿ
ಚೇಂಜ್ ಆಗುತ್ತಾ?
ಅಲ್ಲ ಚೇಂಜ್ ಆಗುತ್ತೋ ಇಲ್ವೋ ಇನ್ಯಾರು. We don't know. Further.
It will come. It's list on 22nd. I'll hear it.
One submission may place on the memo, my lord, the report of the regional commissioner. Copy is already served, my lord.
ಕೊಡಿ, yes,
Please.
next.
But the last occasion, Mr. Vikram had also argued.
Interim order subsisting shall continue to the next item. I'll take it, yes. 20 seconds.
My cases, my lord, the payments are also withheld because of these pending criminal petitions.
My lord, it's
ಇದು
not
ಯಾವುದೋ
correct.
ಒಂದು
No,
ಇದು
sorry, my
ಮಾಡಿದ್ನಲ್ಲ.
lord, my lord, it's submission, this submission is
No,
not
there is,
correct.
Vikram is
Yes,
here.
I'm sorry, my lord.
Ah.
It is not, this submission is
No,
not correct. my lord.
Vikram, relax. No problem. Yes. No, you are panting, yes.
In fact, we have argued on so many occasions. Ultimately, ನಮಗೂ realize ಆಯ್ತು. The issue is only so far as
Identity cards.
identity card. Through tender, this election kit
So,
contains.
is there a case that it is difficult to identify the identity cards?
No, not that much.
Then?
I think the case is simply this, that the officers, Manoj, in fact, one of the accused, some of the accused are our own officers also.
That's exactly the point. Have you spared them or?
No, not spared them. They're also, in fact, I think Mr. Lakshmanaran is appearing for one of the officers. I think Prithvish is appearing for the outsourced agencies, the trust. So everyone is in the dock.
No, corporation has floated tenders for issue of a election kit which contains the identity card.
I will hear it on 20 seconds. Just on, heard ಎಲ್ಲಾರ್ದು ಹಾಕ್ಬಿಡು ವಿಕ್ರಮ್ ಹುಳಿಗಳು senior counsel.
20 seconds.
20 seconds.
Great.
ವೆಕೇಶನ್ ಒಂದೇ ದಿನ ಇರೋದು.
Correct, I agree.
ಅದು 1st Octoberಗೆ ಅವರು ಇಷ್ಟು ಲಿಸ್ಟ್ ಮಾಡಿಸ್ಕೊಂಡಿದ್ದಾರೆ. BB ಪಾಟೀಲ್.
No, in fact, the other day I was noticing lordships were trying to pronounce that judgment and 400 memos were coming and I don't know how your lordships maintain.
Yes. Yes.
Further hearing is on through mail.
It worth, don't worry, yes.
Very well.
Obliged.
Very well.
I'm confident I'll take it. If you are not confident, then we'll see, yes.
Thirty.
Please, madam. Yes, sir.
The issue is directly on the validity. My lords have seen that. Very broadly, my lord, their defense is just twofold.
Filed a written submissions. I am filing a reply to that.
Kodi, sir, give everything. Yes. You should be fast. Yes.
Please, my lord. My lords may straight take their objections. And my lords may see the issue.
Where are the
that-
objections?
Objections
Iva
are-
Kotida.
Illa, they have filed respondent numbers 1 to
Madam,
3.
objections, Kodi.
1 and 3 have filed it.
ಇಂಥ ಕೇಸಲ್ಲಿ ಇರೋದೇ ಇಲ್ಲ ಕೊಡಿ. That's.
My lords, while it is
Give the
found-
objections. Hard copy if you have, give it.
ಗೌರ್ಮೆಂಟ್ ಕೊಟ್ಟಲ್ಲ ಆಮೇಲೆ
Tharsi madam.
ಫಸ್ಟ್ ಟೈಮ್ ಮಾಡಿದ್ರಲ್ಲ
My lord, the scheme of the act is quite straightforward.
Ah.
That under section 5, an expert committee is contemplated that is going to assist the government in framing the rules. Under section 24, 22 and 24, there's a restriction on the amount that can be used for administrative purposes and a mandate that 95% must be used for the purposes that are listed there. Very briefly, I'll mention the list consists of points A to H, H being a residuary clause, and A to G being primary objectives, among which one of them is education. Now, my lords may straight come to section 62, which is the provision that empowers them.
ಇದರದಲ್ಲ what is that act?
Lord, it's the building
Rehabilitation.
and other construction workers regulation. I have an extra copy. I can-
Give me that, yes.
My lords may straight come to section 62.
62.
Please, my lord.
Yes, sir.
And section 5 I just flagged is the provision under which an expert committee is a separate creature under the act, which has to be constituted.
Section 62.
Please.
Power to make rules.
Now, under section 62, my lords will see the first part authorizes the government to make rules.
Yes.
Second part mandates that in particular and without prejudice to the generality of the foregoing power.
Oh, this one, yes.
Such rules such rules may provide for all or any of the following matters, namely.
Yes.
My lords will notice that in subsection 1, it has to be after consultation with an expert committee.
All right.
Once the rules are made, the expert committee's mandate is necessary. One admission that the state candidly makes, which has troubled the apex court also in a judgment that was passed, was that there is no expert committee at all. And there has been no consultation at all, no data been collected. The second issue, my lord, comes from Annexure R1 to the objections. My lord may straight have Annexure R1. To only peruse the manner in which the impugned notification has been brought about.
1 minute. Sir. R1, also the statement of objections.
Please, my lord. It's a letter dated 13th of October 2023.
Objections by whom? State.
Objections by respondent 1 and 3.
1 to 3 state. Yes.
Please,
R1.
R1, page number 8. My lords will see in the very first.
In 1023.
Yes, yes. And my lords will note that the impugned notification is 31/10/23. It's a mere 2 weeks thereafter.
All right.
They invoke section 62 along with rule 45, under which the education assistance is provided for.
Yes.
And there's a tabulation where they say that over in para 1, they say number of years, number of applicants have gone up.
Yes.
And they say in 2022-23, 11,13,000 applications are received, but eligible applications are 9,61,000.
All right.
Therefore, on that basis, now my lords will see para 4 what they say. ಮಂಡಳಿಯ ಪ್ರಸ್ತುತ ಜಾರಿಯಲ್ಲಿರುವ ದರಗಳಿಗೆ ಅನುಗುಣವಾಗಿ ಶೈಕ್ಷಣಿಕ ಧನ ಸಹಾಯ ನೀಡಿದ್ದಲ್ಲಿ ಪ್ರತಿ ವರ್ಷ ಕೇವಲ ಶೈಕ್ಷಣಿಕ ಧನ ಸಹಾಯಕ್ಕಾಗಿ ಮಾತ್ರ ಅಂದಾಜು 1,500 ಕೋಟಿ ರೂಪಾಯಿಗಳು ವಾರ್ಷಿಕವಾಗಿ ಬೇಕಾಗಿರುತ್ತದೆ. My first submission, my lord, is that this figure is absolutely without basis, which is established by their own reports and the CAG report, which I will point out to. The second, my lord, and this is the troubling aspect, there has been no application of mine. And in para 5, what they do is to say that without application of mine, no expert committee, there is no board also. They say we will simply adopt what the social welfare department has notified, and we will apply the same for 10 standard, first standard to 10 standard. But Snatakotra for anything PUC and degree onwards, we will just double it, which, my lord, is a minuscule sum compared to what is provided under the fund. The most troubling aspect, my lord, is in para 6. My lords, please have it.
Yes.
ಪ್ರಸ್ತುತ ಮಂಡಳಿಯ ಸದಸ್ಯತ್ವವನ್ನು ರದ್ದುಪಡಿಸುವುದರಿಂದ ಮಂಡಳಿಯ ಪುನರ್ರಚಿಸಿದ ನಂತರ ಈ ದರಗಳನ್ವಯ ಘಟನೋತ್ತರ ಅನುಮೋದನೆ ಪಡೆಯಲಾಗುತ್ತದೆ ಎಂಬ ಅಂಶವನ್ನು ತಮ್ಮ ಆದ್ಯ ಗಮನಕ್ಕೆ ತರಲಾಗುತ್ತದೆ.
All right.
The day when this decision was taken, my lord, this is notified. There was no board, there was no expert committee. Merely 2 weeks through the Dasara vacations, a letter is sent, and on 31st of October, with retrospective effect to impact even students who are already enrolled, the notification is set out.
All right.
The state does not dispute any of this. In fact, this is their stated case. The troubling aspect comes, my lord, is to justify this move. They suggest that there are no funds available. This, my lord, the CAG has taken a serious view of to say a few things. I will just give the broad heads. First is that there is diversion of funds. Matters that are.
Where do I get that?
I've prepared, my lord. If I may just assist my
Give
lords
that,
with.
yes.
I've tried to crunch down all the figures into few. I'm just handing
Yes,
this
give
over.
it. You have culled it out from the report, right?
Yes, everything is from their reports.
Yes.
My lords may straight go to the very end, my lord. There is at annexure G, page number 68.
I have to, my lord, go through this.
No, no.
It's all there.
No time. It is culled out from the report.
All from the report
Don't
with,
take time at all.
and I've given the page reference.
I'm going to finish this today. Yes.
How do you respond?
My lords may.
Respond. Why, sir? Is it not from the report you know, sir?
Full.
Everything
No, sir,
is from-
everything is from the
all
report
is
you
from-
know, sir. No, I'm not adjourning it even for a minute. Yes.
And to assist, my lord, both sides, I've culled out the specific page number from where the data is taken.
Yes.
Page 69, my lords will have. We've culled out of image here. My lords will see in 23, 24. Do my lords have it? At page
60?
69.
Yes.
We've depicted the figures in the form of an image graph. My lords will see towards the end in 2023-24. I've put a legend there. In the prior fiscal year, the administrative costs exceeded the educational funding.
21, 22.
23-24, last year, my lords.
Yes, 23, 24.
In fact, my lords had passed one order on a previous occasion saying, let them file a statement saying how much they're spending for administrative purposes.
ಅದು ಹಾಕಿದ್ದೀರಾ affidavit?
Yes.
All right.
I will point out to that affidavit also as to why that those figures they have mentioned are inaccurate or incorrect. Now, my lords may see the next page. CAG makes another finding that by mere negligence, which is by not applying for an exemption under section 10, subsection 46 of the IT Act, over 3,000 crores have been spent in unnecessary tax liability. So what has happened, my lord, is that just because an exemption was not applied for, tax liability has accumulated.
Who had to apply?
The board, my lord,
Board
the state. And thereafter, what happens is that they do not also file their statements on time, as a result of which penal charges are levied. All of this, my lord, is at page 295 of volume 2 of the writ petition.
You have said so in this?
Yes, it's in. This is a CAG report, my lord.
All right, next.
Now, just to give a, because their entire cases, the funds are not available, what is shown at para 70 is that just by avoidable tax liability, 7 years worth of the program can be run for all the students at the 2021 rates. And even if I double that amount, it can be run without any more, assuming no further cess is collected for 4 years and 9 months. So an argument to say that for a statutory duty, funds are not available, my lord, is not a defense that the state can take. And even assuming that there is some weight to say that, yes, funds are deficit, that is not the factual scenario. Because even that figure of 1,600 crores is without basis. The next page, my lords will see page 71. This is a representation of the inadmissible and wasteful expenses.
Yes, that I have seen.
Yes. All of this, my lord, is cumulatively more than all the amount ever spent on education. Just the wasteful expenses.
Yes.
And now, my lords will just have page 72 for a minute.
Yes.
My lords will see the number of inadmissible heads under which money is being spent. For example, my lord, there are unauthorized training schemes that are for which money is being doled out to the extent of 745 crores. The CAG has taken issue with this, saying under what head are you spending this money? And are these going to third-party contractors who do not have a place under the scope of the scheme. And to just give two examples, my lord, Manrega government schemes that have nothing to do with the act, Manrega, and also the Indira Canteen scheme is being funded through money that has been collected in under the act. I will only point out the two heads. My lords will see on page 72, from the bottom of the page,
Yes,
there's Manrega related expenses.
7 crores.
Yes, my lord. And Indira Canteen,
That is
18
18
crores.
crores. Hmm.
These are only two examples, my lord. The list is very long. Even contracts that have been given to Kionics for some software related work.
Goes from this fund?
Yes, it has gone from this fund. The work has not been completed, and the ones that have supposedly been completed have been of no use. And
Yes.
what the CAG notes with some concern is that to overcome the tendering process, works in excess of 10 crores have been broken up into smaller segments of less than 10 crores so that a tender notification does not have to be.
It's all right. That will.
Yes.
Yes.
Now, my lords, coming to the, so in sum total, what my lords see, my lord, is that the entire argument that 1600 crores will be needed to fund the project every year if the erstwhile notification is maintained is fallacious for the following reason. The CAG has accounted how much it costs on an average per student to run the scheme. That figure, my lord, that's at Annexure AB, AK,
Yes.
and my lords will see at page number 432.
Yes.
My lords will take page 445.
Where is the apex court saying something?
I've also placed the judgment on record.
Yes.
I'll quickly.
Where
run
is that?
My lords may just take page 445.
45 of the petition?
Yes, my lord. 445. This is in volume.
445.
Volume 3, Annexure AK.
Volume 3.
Yes.
Volume 2. Volume 3. Volume 3, yes.
Annexure AK.
AA.
AK. A for
Okay.
K for Karnataka.
Yes. Page?
445.
445.
Please, my lord.
Yes, sir.
My lord, this is the only record with some authenticated numbers. The state has not provided any. This is pertaining to Karnataka. Education, my lords will see, average per beneficiary. The cost is 5,261 rupees.
Yes.
My lords may, only for the sake of testing their argument, double it by 50% to take it closer to 7,000 odd. Even then, my lord, the entire program on the notification of 2021 without considering the notification that has now been impugned is in the range of 500 crores to 700 crores.
Yes.
So the argument that we need 1600 crores does not hold water. My lord, this is their figures. And to add to this, my lord, in their audit statement, the audit statement that the government has now placed before this court, they have spent less than that amount. They have spent on an average about 2,000 rupees per student, which brings the figure less than 500 crore. So the only argument that has been placed in the objections is to say that we have a budgetary constraint. The budget is capped at 500 crores and we cannot spend more than that. On the first submission, my lord, 500 crores itself may be sufficient. But the second is that even if it were to need more, that is not a defense to say that statutory obligations will not be discharged. The third issue, my lord, that is troubling, and it came up in a previous order of my lords, is the FDs that have accumulated. And the Honorable Supreme Court has also come down heavily on this. I will only refer to one order of the Honorable Supreme Court.
Page.
My lords may, it's here. My lords may straight have their, the affidavit filed by R2 on the statement of expenses.
Yes. That is dated 26/7/24.
Please, my lord.
Page.
This is, yes, 26/7/24. And I will also show the Honorable Supreme Court's order.
Take me to the apex court's order.
Yes. This is, my lord, at page number 15 of the written submissions. This is in writ petition number 318 of 2006. Order dated 2nd August 2017.
Apex court's order.
Please, ma'am. 2nd August 2017. at page-
2017 order, is it?
Please, my lord.
Yes.
Because there's a direction as to how the FDs have to be used, or how the accumulated funds need to be used.
Where is your written submission, sir? Page?
Page number 15, my lord.
Ah, you've taken me this through.
Yes. I will only point out to, because they specifically said that they have placed more than 6,000 crore rupees in FDs. The Honorable Apex Court at page 20 is the operative portion.
Yes.
Has come down heavily with this practice of funds lying unused, and say we reiterate our earlier direction given on 7th of February 2012. This is on page 20, my lord. The funds available with the welfare boards which have not been dispersed or are not likely to be dispersed within a short period should be properly invested with the nationalized banks only. Funds available with the welfare board shall not be utilized by the state for any other head of expenditure of the state government.
All
Both
right, I'll
counts.
continue to
Please.
that.
Let's.
How long will you take?
My lord, I'll wrap it up.
Wrap it up fast.
Yes.
My lord, serial number 132, my lord. I pray for 1 week time, my lordships. Interim order may be extended.
My lord, serial number 50.
Yeah. This second list matters. I'm
List
not
one,
taking.
list one, my lords.
List one will see, second list matters will see, whatever, all after vacation. Yes.
Serial number 50.
Whichever time you want, please take.
It is
Please.
infractions, my lords.
Adu kodi.
It's not infractions.
Season number 30.
you.